matters that the defense will be looking into. And so we are going to reset him for tomorrow.
See you tomorrow.
Do you want to just attach this to this?
You'll get it again tomorrow.
Thank you. Reason to reset him is that the defense is going to look into possible alternatives for him. Please state your name.
Stephen James Aaron.
Yeah.
Sir, you're here with regards to a warrant on a failure to appear on a charge of operating a motor vehicle without a valid driver's license. The judge has set this at a no bond status.
Your Honor, the offer from the state is an adjudication, credit time served, court costs, and we would like to accept an enter plea of no contest. Thank you.
I'm not going to accept the plea at this time.
Turn myself in.
Your Honor, he turned himself in. It's, he doesn't have anything other than a no valid driver's license charge. It's not a driving while license suspended, so usually we're more cautious of those charges, but since it's just a no valid, and it won't habitualize him.
And so, normally speaking, on a charge like this, when there is a failure to appear, the court would double the bond amount, 250 to 500 or whatnot. In this particular case, the judge set the warrant at 0.
We plead the failures to appear, even when they're set at 0, Your Honor.
Do you have any information as to why the judge would have set this at 0 bond, knowing that normally what they would do on a failure to appear on a charge like this is double it? And so I'm not going to second guess what that judge was looking at,
I'm gonna have to.
so I'm not going to take a plea on this case. All right. You are represented by the Office of the Public Defender. If they haven't been appointed beforehand, they are now. All right, thank you, sir.
No, I don't have one for you yet.
Leslie Garrett, bonded.
Please state your name.
Morgan Stevens.
You are here on a Capias with regards to a charge of driving while license suspended or revoked with knowledge. The judge has set the bond on that matter at $2,000. I'm appointing the Office of the Public Defender to represent you.
And Your Honor, the offer from the state is a withhold of adjudication, credit time served. Well, the withhold and court costs, and Ms. Stevens would like to accept an enter plea of no contest.
Does the state have a driving record?
She has no driver's license, Your Honor.
He has no driver's license?
No, Your Honor. When I pulled the file and looked at the driving record, it said none.
All right, but is there a driving record still? Is there any type of history in the driving record?
One moment, Your Honor.
That was the only thing I could see.
Normally, I would have you looking at a driving record. I don't have one.
Let's see.
So I don't know if this resolution makes sense or not.
I don't
You don't have one either.
have one, I don't have one at this time, Your Honor.
Do you have access to David?
I do not.
If you look in the, in Odyssey, Your Honor, it says no driving record found. because they usually upload it in Odyssey, the driving history, but it says no driving record found, and that was ran May 19th.
Yes, Your Honor, we usually provide those driving histories, but she doesn't have a David for me to print.
I'm so sorry?
She
She
doesn't have a David for me to print any driving history.
I'm so sorry. She doesn't have a,
She does not have a driving history, Your Honor.
in this state?
As I'm pulling up in the judicial inquiry system in JIS, she doesn't have one. One doesn't come back at all.
In this state? Or does that encompass anywhere?
It seems like that's anywhere, Your Honor.
So sorry?
It
And I'm
seems
so-
like that's anywhere because it gives us the option to click out of state and nothing is coming back at all.
Anywhere? Okay.
Nothing.
And I'm sorry, it's just that there's a machine here, and with that noise, I can't hear you too well because it's kind of like bouncing here. And so you're saying that the system that you have indicates that there is no driving record anywhere in the U.S.?
Yes.
All right, thank you. Bear with me a second. Thank you. So part of the reason I ask about if she has a driving record anywhere is that there is an indication on the citation that she got indicating that she had something in the state of California.
Yeah, I was just about to ask, does she have like a ID number or something?
She said she had one in California.
And please don't say anything. Everything you say is being recorded. And so without knowing what her prior driving history is, I feel hesitant to take a plea.
In California. It was in California.
In counsel? So as I said, I feel hesitant to take a plea at this time, because I don't know what accepting a plea at this time may affect anything that she may have in another state.
She's willing to accept that chance and accept the plea here today.
And as her attorney, are you willing to to advise her to go forward on this at this time? Do you need more time to get information? I don't mind giving you more time if you need to look into this.
If, would you be able to pull it from California? Because we don't have access to pull. If you could get more, I don't know what you would need that, for me to get from her in order for you to pull it, so that if we reset, could you afford a $200 bond? Because it's 200. The bond that was set for 2,000. You can afford that?
The other thing is that depending on if she has a prior driving record, I may not agree to a withhold.
Yeah, I know what you're saying. Your Honor, I don't know, is there anything that I could give you that you could pull it, Rebecca?
I got it. We needed a certain state.
Okay. So she has the record, you have the record? She cannot afford the bond, Your Honor. She'll be held. Yeah.
Oh, thank you.
I just need that.
Thank you.
All right, so I've been handed what appears to be something of a summary of a driving record from California. And thank you for this. And it's in a format that's a bit different than what we're used to, but it appears that she had an ID card in California. Her driver's license was suspended because of a failure to appear in 2018, I believe it was. She appears to have had some type of situations in the state of California. And so at this point, I would not be I would not be imposing a sentence of a withhold. If there was a plea to the court, it would be an adjudication. How much time short does she have?
2 days.
2 days. Thank you.
This occurred back in 2016.
And so, in reviewing the underlying file in this state, I see where she had written to the judge indicating that there was a reason for not appearing, indicating something with regards to school. I would think that if it's a matter of, I normally would not touch a bond amount on a warrant, but under the circumstances, I might.
Yes, Your Honor, I was just talking with Ms. Stevens. I was letting her know we do have an amazing program to help her get her driver's license. So we were speaking about the bond issue. If you could consider reducing the $2,000 bond, she would be able to afford the bond amount and.
Well, of how much?
On my paperwork, it
It's
says,
ROR.
right, it says 2,000/ROR.
On the charging affidavit or the warrant?
No, I don't know.
The warrant arrest affidavit, the thing that we generally see.
The warrant signed by the judge says 2,000. It doesn't mention ROR.
Okay.
Some
That may be
officers
it.
sometimes put that.
I would tend to think that the judge would not put ROR on failure to appear on this type of charge.
Your Honor, would you consider reducing it to 1,000? Because she's going to have to put up the entire 1,000, given the FTA is when she spoke with the bondsman, but she is willing to do that in order for us to help her get her driver's license.
State have any position on this?
No, Your Honor.
All right. And this is something that I rarely do, but under the circumstances, seeing that there was an attempt to communicate on a failure to appear with the court, I am going to modify the bond amount to $1,000 and also highly recommend that you take advantage of the assistance offered through the Office of the Public Defender with regards to their program to try to get you a valid driver's license.
And, usually, I don't believe we were appointed, so could you just appoint us, Your
We're
Honor?
going to appoint the Office of the Public Defender to represent you. I am going to require that you not drive without a valid driver's license. Now, if you get caught driving without a valid driver's license, you're looking at a much more serious situation.
Yes, sir, I bought a bike for this exact reason.
All right, so I just want to make you aware there can be severe consequences if you are caught driving without a valid driver's license, but also that there is an opportunity to perhaps be able to get a valid driver's license.
Thank you.
So here's the telephone number. You can call to get the information and I'll tell you about the program and what you can do to help you get your license, okay?
Your aim, behavior, Your Honor.
Who?
Is that paperwork?
Oh, AIM.
Thank you so much. I'm so sorry, sir. May Joel?
Your aim, behavior.
All right, thank you.
And I will waive the appearance, Your Honor.
Thank you. This is with regards to charge of count 1, burglary of an occupied dwelling, bond set at $5,000, count 2, criminal mischief, bond set at $100. I've reviewed the charging affidavit, find probable cause. I'm appointing the Office of the Public Defender to represent him. There is a,
Your Honor, in regards to his out on bond, we weren't too sure if he was indeed out on bond or if the case was still open, if the PD and the state could help, because he
know.
was found incompetent to proceed, but his last date,
Looks like they closed it.
yeah, this
Yeah,
is
it
with
was
regards to
reclosed.
case 2021 CF 4690. And so, yeah, I noticed there was nothing on the sheet other than the case number, so I was going to inquire what is happening there.
it's an incompetent to proceed case.
Incompetence proceeding?
It looks like they closed it, something about, he was supposed to be going to Aspire. He had a private attorney, but then all I see is that it was closed. I didn't see any.
All right, how about if we do this, with regards to the bond amounts, we'll keep the bond amounts for mental health pretrial release?
He doesn't qualify, Your Honor. He's been,
He's already been adjudicated incompetent?
well, no, like they already
Screened him.
have him screened before prior. He never qualified.
All right, thank you.
Your Honor, welcome.
All right, well then, at this point, not knowing exactly what's happening with the 2021 CF 4690, I'm going to take no action on that.
I apologize, Your Honor. Can you repeat the bond amounts for the burg dwelling and the criminal mischief?
Yes, on the burglary is 5,000, on the criminal mischief is 100.
And did you also do a no return and no contact?
You took the words out of my mouth. There will be no return to the place where this incident took place and no contact with any witness or victim. Okay,
Romello Alexander, refuse.
okay. I'm appointing the Office of the Public Defender to represent Mr. Romello Alexander. This is with regards to charges of count 1, possession of cocaine with intent to sell or deliver, count 2, possession of meth, count 3, possession of fentanyl. I've reviewed the charging document, find probable cause. Count 1 is set at $15,000, count 2 at $150, count 3 $150. There's an indication that he is presently out on bond with regards to charges, possession of a firearm by convicted felon, possession of firearm ammo by convicted felon, and possession of meth. I'm going to revoke on that bond and set it at a no bond status.
And you appointed,
I'm appointing the public defender to represent him.
thank you, Your Honor.
Are you waiving?
And I will waive the appearance.
Thank you. Please state your name.
Shelton Lewis Ogburn.
Thank you. You are here on several matters. First, arrest affidavit has 3 counts. Count 1, criminal mischief. Count 2, burglary of an unoccupied dwelling. Count 3, possession of a controlled substance with intent to sell. I've reviewed the charging affidavit, find probable cause. Bond on count 1 is $1,000. Bond on count 2 is $5,000. Bond on count 3 is $15,000. Second arrest affidavit has a charge of violation of failure to report on a certain case, matter.
Yes, I will waive the reading, Your Honor.
Thank you. And bond on that is set at a no bond status.
Your Honor,
That's on a warrant.
yes, they come in at no bond, Your Honor. You have to set the bonds on those counts. They all come in at no bond.
State,
That is correct, Your Honor.
is he entitled to a bond?
Yes, Your
On
Honor.
a failure to report on this
On
type
that
of case?
offense. Yes, Your Honor.
Oh, I see where it's saying it. All right, I'm setting bond. At $5,000 to comply with all reporting requirements. Please bear with me a second. All right, and so it's, the warrant is indicating to comply with all reporting requirements within 1 day of his release. Does that address all issues, state defense?
Yeah, did you do the FTA warrant he had?
He has an FTA warrant?
Yes, a 2019 CF.
Oh, I see, thank you. Third one is a failure to appear with regards to an underlying matter of failure to report. That Capias is set at a no bond status, and it's indicating that was for failure to appear at a trial management conference on June 27th of 19. and that warrant does not indicate any type of modifications. So it's staying at a no bond. Yep. All right, thank you, sir.
Jason Benitez bonded.
Thank you. Your name, sir? And sir, you are here with regards to matters involving count 1, aggravated assault with a firearm, count 2, principal to criminal mischief, over $1,000, count 3, discharging firearm in public. I've reviewed the charging affidavit and I find probable cause. I'm appointing the Office of the Public Defender to represent you. Is there any comment from the state?
No, Your Honor, he is entitled to a bond on count 1.
Any comment from the defense?
No, Your Honor.
All right, I'm going to set bond at $50,000. You are not to return to the place where this incident took place. You are not to have any contact with any alleged victim or witness regarding this case. Anything else from the state or defense?
No, Your Honor.
No, Your Honor.
All right, thank you, sir.
And you're staying the bonds in the other 2 counts, Your Honor?
Thank you. With regards to count 2, the bond was set at $1,000. With regards to count 3, the bond is set at $100. All right, thank you. Please state your name.
Anthony Calova.
Sir, you're here on Capias with regards to charges of possession of methamphetamine, battery on a law enforcement officer, and resisting officer without violence. This is a Capias, and the judge set these at a no bond status. I'm appointing the Office of the Public Defender to represent you. Any comment from the state or defense?
Nothing from the state.
Nothing from defense, Your Honor.
Thank you. Please state your name.
Isaac Ledesma.
You are here on a capias with regards to a failure to appear on a violation of probation status hearing, underlying charge of carrying a concealed firearm. The judge has set that at a no bond status. I am appointing the Office of the Public Defender to represent you. Do you understand what I have said, sir?
Yes, sir.
All right, thank you. Please state your name.
Christian Letters.
You are here with regards to an arrest affidavit with 3 counts. First one is possession of cocaine with intent to sell or deliver with a firearm. Please bear with me a second. Yes, okay. Count 2 is possession of methamphetamine with intent to sell or deliver. Count 3 is possession of fentanyl. I have reviewed the charging affidavit and I find probable cause. Bond on count 1 is set at $15,000. Count 2, $150. Count 3, $150. Any comment from the state or defense?
Nothing from the state.
Nothing from defense, Your Honor.
There is a notice that you are out on bond with regards to a possession of meth. I'm going to revoke that and set it at a no bond status. Thank you.
And you're gonna And you will appoint on the out on bond as well, Your Honor?
Yes.
Thank
If-
you.
If it wasn't clear, yes, I'm appointing the PD on all matters involving this person. Good afternoon. Please state your name.
My name is Stacy McDonald.
Thank you. You are here with regards to a warrant on a charge of aggravated assault with a firearm. Bond is set at $3,500. I'm appointing the Office of the Public Defender to represent you.
Okay.
All right.
I don't have access to a firearm or just a false
Hold
report.
on. Everything you say is being recorded and can
That's
be used
fine.
against you. The attorney is standing next to you. If there's something you wish to let the attorney know right now.
Okay. Okay. Okay.
All right, thank you. Your name, please?
Mr. Daniel McDormand.
You're here on two matters. You have a count one, possession of heroin, bond is set at $1,000. Count two, possession of drug paraphernalia, bond is set at $500. I've reviewed the charging affidavit, find probable cause. I'm appointing the Office of the Public Defender to represent you. Anything from the state or defense?
Nothing from state.
Nothing from defense, Your Honor.
All right. Do you understand everything that was said, sir?
Yes, sir.
All right, thank you, sir. Please state your name.
Tremaine Mitchell.
You are here on two counts. Count one is criminal mischief. Bond is set at $1,000. Count two is burglary of an unoccupied dwelling. Bond on that is set at $5,000. I've reviewed the charging affidavit, find probable cause. I'm appointing the Office of the Public Defender to represent you. Any comment from the state or defense?
Nothing from defense, Your Honor.
Your Honor, I'd ask for a no return.
I'm going to require that you not return to the place where this incident took place, which is state.
1788 North Hiawassee Road.
Thank you. All right, thank you, sir.
All right. Wait, you saying?
Please state your name. Your name, please. Can you hear me okay? You
I
can't
think
hear
he
me?
may need the hearing device, Your
Yeah.
Honor.
Is there a hearing assistance device in the courtroom? Testing, testing. Can you hear me now? Or can you hear me well?
Yeah.
All right, good. Thank you. Please state your name.
Wolf Purdy?
And you are here with regards to a warrant arrest for a failure to register.
I will waive the reading, Your Honor.
Thank you. And I'm appointing the Office of the Public Defender to represent you. And the warrant has set a bond amount of $10,000. You understand everything that was said?
Yes, sir.
All right, thank you.
Why is that looking?
Please state your name.
Let me get this up.
And I'm sorry, the last name was,
And,
your last name was,
Sims.
thank you.
wait.
You're here on a matter of three charges. Count one is fleeing or attempting to elude a law enforcement officer with sirens and lights activated. Count 2 is driving while license revoked as a habitual offender. Count 3 is resisting officer without violence. I've reviewed the charging affidavit, find probable cause. I'm appointing the Office of the Public Defender to represent you. Counsel, is there something you'd like to let us know?
No, Your Honor.
Okay. State, anything?
Nothing from the state.
All right, well, count 1 is set at no bond.
I apologize. He is entitled to a bond for that, Your Honor.
Right. And so with regards to count 1, I'm setting bond at $10,000. With regards to count 2, I'm setting bond at $2,500, and with regards to count 3, $500. Anything else from the state or defense?
No, Your Honor.
All right, thank you.
Carolyn Smith bonded.
Carolyn Smith bonded? Okay, thank you.
Melvin Torres Flores bonded.
I don't have time to calculate.
All right, thank you.
And Steven Zamora bonded.
Mm-hmm.
Good afternoon,
So I
sir.
don't know who it is.
Can you please state your name?
My name is Henry St. Louis.
All right, thank you. You are here with regards to a warrant that was issued for your arrest with regards to a charge of first-degree murder. Has the PD been appointed on this already, or?
Henry? I'm just trying to make sure, because my note from our office, it stated he's represented, he has private counsel.
You want to take a moment and just ask?
That's why I'm double checking the notes that they sent me this morning. He's being Joshua Adams is what I have, Your Honor, from my supervisors. He has a private attorney, Joshua Adams.
All right, thank you then. All right, sir, do you understand everything I said?
Yes,
Your Honor.
All right, thank you, sir.
Was he supposed to be here? Because of the seriousness of the offense, Your Honor, I don't know if he put a notice in, that's why I'm trying to double.
Teleconference? Just video conference.
Yep, he filed a notice of appearance.
Welcome to an Econo meeting. You are entering the meeting now.
And now what?
Can we reset? I mean, can we push him back towards the end?
To the end, no.
Ah. Well, he has an attorney. He has a first, I don't know what to do because he put a notice to appear. Sometimes they come at 1:30. That was the only thing. I don't know.
Do we know for sure he's going to?
See? There he is. I don't know who that is. That's statewide. Oh, he has a second-degree murder.
I see some individuals on the television screen. I am Judge Martinez. I am addressing the case of Henry St. Louis.
Second degree.
We were looking at the possibility of his private attorney appearing via teleconference. Does anyone on the screen know anything about what I'm talking about?
No, Judge. We're here for Victoria Newsman Teixeira.
Okay, well, thank you. Is that okay? If you will please bear with us and
I really
hold
don't know
on.
what's
Okay?
going on with this case.
Yes, Your Honor.
Thank you, Judge.
You're welcome. So, Mr. St. Louis, it's our understanding that you have private counsel on this case, and I would imagine that your attorney is going to be communicating with you in the very, very near future. All right, thank you, sir.
Your Honor, did you say what the bond was?
This is set at a no bond status. I'm sorry if I didn't say that on the record, but this is a warrant with regards to first-degree murder, and it has been set at a no bond status. All right.
You sure? Can you look?
Hold on.
I
Everything
don't-
you say is being recorded and can be used against you. And with this particular
right.
type
File
of charge,
as a-
I would
did you guys file it?
advise that you please wait till you talk to your
Okay.
attorney about this.
Speaking about the fact about this case, I
So
was,
sorry?
I'm
He's
not,
talking,
I wasn't gonna speak about the fact about this case.
because, see, I was looking
Hold
here.
on. I really am leery to
So that
have
was
you
the old
speak
case.
in open court without an attorney representing you. I'm very, very leery about that.
That's my issue, Your Honor, because of the seriousness of the offense. And he has no attorney here. I don't know. Let me,
What is the deal?
Wait.
I need to pull something out of.
that's why I'm your attorney to be present.
Yes, counsel?
I would ask that it be reset for tomorrow to give him a chance to speak with his attorney so he can actually appear. Apparently yesterday he appeared telephonically because of, he was experiencing issues with his health. So I would just ask, because this is such a serious offense, he's a young client, he really has all these questions, and he's represented by counsel. I would just ask that it be reset for tomorrow to give counsel a chance to appear.
It's my understanding that this individual is a juvenile and needs to be transported ASAP to the juvenile facility. And that's one reason why it was pulled up in order. I am leery to have him stay in an adult facility at this
Oh,
time.
I understand. It's just the issue that he doesn't have an attorney, he's not represented, and
I thought he had an attorney.
he does, he's not here today, Your Honor. So I don't know,
And
I can't answer.
right, and that,
My attorney on the second degree, it got changed to first degree. So
Right.
How does that work? Does he still stay on the case, or?
Yes, it's still showing he's on the case.
all right, at this point, I appreciate that
I don't know.
he's got a lot of questions, but because of the seriousness of the situation, I am leery to have him say anything.
Yes,
Or even
I am
ask
as well.
questions.
Mm-hmm.
Your attorney has to be in contact with you in the very near future. Do you have a telephone number for your attorney?
No, I have his email.
Okay, well, perhaps the Office of the Public Defender can facilitate or help him get a phone number where he can call his attorney's office?
Yes, if you can, just sit him in the cell just for 5 minutes so I can pull that up for him.
All right, why don't you bear with us, and counsel here is going to try to get you the phone number for your attorney so that you can call the office, okay?
How do I speak to him?
You should be provided access to a telephone where you can call your attorney.
Your Honor, the phone number that I have for Joshua Adams is 321-314-2828.
321-384.
No, 314-2828.
2828. So 321-314-2828?
Yes.
All right, counsel, would you please take a moment and let him know the process where he can call? Thank you. Okay.
Thank you.
There is a notice here. Madam Clerk wants to hand them a copy of the document. And thank you.
So we still on I'm not.
So that the document that is being given to you now also has a second phone number for the attorney.
Oh, this is the other number he has? Hold on.
That's the number listed on the notice, so just in case.
I'm gonna try to email him.
Can you just give that to him?
Yeah, it's just a copy.
I'm gonna try to email him right now, then, just so he knows. All right. But that's his information, right here. His phone number, his office phone number, assuming this is the
So
cell.
I got one that I think for the other
Sir,
one.
I cannot answer those. You gotta make sure. That's why I'm telling you. You gotta address it with him. You don't represent. You already filed his notice. You're gonna have to talk to him one-on-one. That's the issue.
All right, thank you, counsel. Next on the list, I have a Kenneth Hardy. Is that correct? Please state your name.
James Hardy Jr.
Is this a pleable?
Yes, it is. It's usually a city offer, which is a withhold of adjudication and credit time served.
So just to, some of the people, Your Honor, weren't brought up, so I wasn't able to talk to everyone. They were still bringing some of the people up at the time.
All right.
Yeah, he has that. I'm just making him more.
Sure.
All right, Your Honor, the offer from the state is a withhold of adjudication credit time served. Mr. Hardy would like to accept and enter a plea of no contest.
Is that the offer state?
Yes, Your Honor.
And you said this was a city case?
Yes.
Do you get the offers from the city attorney?
We have a standing understanding that for the majority of their cases, it is a withhold and credit time served. We do have the discretion to alter that, but 90% of the cases are a withhold and credit time served.
Do you have the authority on behalf of the city attorney's office by some type of understanding to make these offers?
Yes, Your Honor.
And let the record reflect the plea form was signed in open court. Mr. Hardy, do you understand the rights that appear on the front of this plea form?
Yes.
You understand you're giving up those rights by entering a plea here today?
Yes.
You understand the maximum and minimum penalties with
Yes.
regards to the charge that's bringing you here today?
Yes.
You understand you're giving up your rights by entering a plea here today?
Yes.
And sir, are you under the influence of any alcohol, drugs, or medication that might affect your thinking here today?
No.
Do you suffer from any type of mental condition or disease that might affect your ability to think clearly?
No.
Sir, with regards to the charge of soliciting without a permit
Yes.
from an incident of July 11th, 2022, how do you plea?
No contest.
Accept the plea of no contest, find you're alert and intelligent, understand the rights and the penalties associated with the charge, you're entering the plea of your own free will. At this
Yes.
point, I'm going to withhold adjudication. On the charge, I'm going to impose upon you all applicable court costs and fees, and we're going to require that you pay those within a one-year period. You have
Okay.
30 days to appeal the decision of the court in writing. If you cannot afford an attorney for appellate purposes, one can be appointed for you if you qualify. Thank you, sir.
Thank you.
You'll be released as to this charge.
I can't breathe. Trying to email this guy.
interpreter, can you hear us?
Yes, sir. Can you hear me?
Yes. Can you please identify yourself for the record?
My name is Isabel Rocher, court interpreter, Creole.
Thank you. And can you please state your name?
My name?
No, I'm looking at the defendant.
Oh, I'm sorry.
No problem.
Qui Jean Ourele? My name is Monica. The interpreter is hearing the defendant faintly, very faintly.
I'm sorry, I didn't understand the last comment from the interpreter.
The interpreter can't hear the defendant very well.
Okay, the microphone is being put closer to her. Hopefully that
Okay,
will help.
perfect.
And if not, please let us know, okay?
Okay.
Are you able to tap into the video here?
I am not.
Okay. All right. Here we go again. Please state your full name.
Qui Jean Ourele?
Monica.
Monica?
Monica Alex.
Monica Ali.
You are, you are here on a charge of battery, domestic violence related.
Ou ici pour un cas d'attaque, de domestique violence.
I have reviewed the charging affidavit and I find probable cause.
Moi révisé tout dossier yo, moi joindre que gain assez évidence pour moi accepter bagay yo.
I'm appointing the Office of the Public Defender to represent you at this time.
Ma board défenseur public, bureau défenseur public pour représenter yo, pour aider yo.
I'm going to set bond on this case at $1,500.
M'a mette bonne dans casa à $1,500.
I'm going to require that you have no contact with the alleged victim in the case.
Ou pas capable gain aucun contact avec victime dans casa.
That means that you cannot try to talk to the person in person.
Ça veut dire que ou pas capable parler avec moun là face à face.
You cannot communicate with him by telephone, text, or email.
Ou pas capable relé yo dans téléphone, ou pas capable voyer texte ou bien email ba yo.
You may not try to communicate with him by any type of social media platform.
Ou pas capable essayer communiquer dans les réseaux sociaux.
And you cannot have another person try to communicate with him on your behalf.
Et ou pas capable faire on l'autre moun aller parler à moun ça pour.
You must maintain a separate residence from the victim.
Ou besoin rester dans un cas différent que victime là, ou pas capable rester dans même cas.
You can return one time to the residence with law enforcement to pick up personal possessions.
Ou capable retourner dans cas là une grande fois ensemble avec la police pour aller prendre affaire.
You are to possess or consume no alcohol or non-prescription drugs.
Ou pas capable prendre aucun alcool, ou pas capable prendre aucun drogue qui pas prescription.
You are to possess or control no weapons or firearms.
Ou pas capable gain aucun arme ou bien aucun arme à feu.
Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release.
Depuis ou relâcher toutes armes ou bien armes à feu ou bien munitions que ou t'a gagné ou besoin bailler la police, coup ou relâcher.
You are to maintain a distance of at least 500 feet away from the alleged victim.
Ou besoin rester à au moins 500 pieds de distance de victime là.
Also 500 feet away from their residence,
500 pieds de côté yo rete,
their vehicle,
machine yo,
their place of employ,
côté yo travail,
their place of worship,
côté y a l'église,
their place of education,
côté y a l'école,
and any stores that you know they frequent.
et tout magasin que vous connaissez côté yo pralé a.
Any comments, state or defense?
Nothing from the state.
Nothing from defense.
L'État pas rien pour dire.
All right, thank you, ma'am.
OK? Ou fini, madame.
All right.
I have a question.
please understand that everything you say is being recorded and can be used against you.
Tout ça ou dit, yo enregistré li et yo capable d'utiliser le contre ou même. Ou besoin comme ça.
And because we're using an interpreter, there's no way to provide the ability for you to have a confidential conversation with the assistant public defender in this courtroom.
Et peut-être ou gen un interprète qui parle pour, pas gen aucun moyen pour ta capable gagner une conversation privée avec avocat.
Do you understand what I've said?
Est-ce que vous comprenez ça moins d'où là?
So do you have a question about the bail bond that I have set or the conditions of release? Is your questions with regards to anything I have said?
Est-ce que question que vous gagnez, est-ce que il y a un rapport avec ça juge l'a dit ou? The interpreter cannot hear the defendant.
Listen to the question. Do you have a question about the bond I have set or the conditions of release?
Est-ce que vous gagnez question sous bande que juge la bord ou bien condition pour capable sortir? Est-ce que vous gagnez question sous ça?
Question, est-ce que c'est $1,500 comme il y a $1,500 pour moi payer?
The $1,500, is it something that I have to pay?
You can pay that, yes, in cash, or you can go to a bonding agency. And
Ou capable payer les cash ou bien ou capable aller dans bondsman?
the bonding agent, I believe you give them 10%, and they put up the rest on your behalf.
Non bondsman, il y a ou bayo 10% de quantité l'argent ça et puis il y a mettre reste là pour. Pardon?
Moi qui l'est ça ou qui l'est pour qui l'est?
When can I do that?
You can do that as soon as you leave the courtroom.
Depuis ou quitter tribunal là, ça le tribunal là ou mettre fait ça.
All right.
Okay.
Bear with me. Okay. Nothing here? All right. Thank you very much. Thank you, Madam
Right.
Interpreter.
Thank you, sir. Bye-bye.
Bye now. We're going to do this case now? Okay. We're going to do that case. Thank you.
Your Honor, can you tell me the defendant's name?
The one that's coming up now is Victoria Nussman Tiexera.
Is that a felony or a misdemeanor?
Felony.
Okay, so, can you please state your name?
Victoria Newsman Teixeira.
All right, thank you. You are here on a warrant arrest with regards to a charge of grand theft of $20,000 or more and a charge of criminal use of personal identifying information. Warrant has set these matters at $250,000 per count for a total of $500,000. And you do have to, if you all can please identify yourselves.
Frederick Wazeski on behalf of the defendant.
Ashley Wright on behalf of statewide prosecution. Good afternoon, Judge.
Good afternoon. And who wishes to be heard?
Judge, I have had some discussions already with Ms. Wright from statewide prosecution in regards to the bond. Just as a bit of an overview, Judge, the defendant is a full-time student at the University of Florida. She lives here locally with her parents, and she has an internship. She's got no criminal history, so we've had a discussion, and I would ask for a significant reduction in the bond amount, and the state has indicated that the amount that I'll be requesting for, they do not personally have an objection to, which we need to reduce it to $2,500 per count. We've already been in discussions with this, and I'm involved in the case. I see it as a situation where there will be no issues with the defendant upon her release.
And State?
Judge, that is correct. I have spoken with defense counsel in this case, and that is a correct recitation of what we discussed. I would like to add or let the court know that the defendant does have ties to Brazil. And so with the monetary bond, we would also just ask that she not be permitted to travel outside of the state of Florida. We have, the defendant has voluntarily surrendered her passport to the state, so we would just ask that she not be permitted to travel outside of the state and that there be no contact with the victim. Other than that, no objection to reducing the bond.
All right. I am put in the unenviable position of sitting here on a temporary basis, doing in-jail arraignments and proceedings. I have touched this case probably for a total of no more than 3 minutes. I am hesitant to change anything on the warrant, as I have no idea what the judge who signed this warrant and set those amounts is looking at or considering. And while I do appreciate the communication between the state and the defense, I have no inkling or idea what the judge was looking at with regards to this case. So I will not be modifying the bond amount, and I would request that you appear before the judge in charge of this case ASAP.
Understood, Your Honor.
Right, thank you all very much. Ms. Nussman, I know that the attorneys here are speaking with each other, and I'm sure that they will work with each other to get before the judge who is going to be handling this case on a more permanent basis to help you out with this matter. Now, I understand, I don't mean to be disrespectful. I'm just trying to avoid you from speaking because everything you say is being recorded and can be used against you. But you do have an attorney who's representing you, is aware of my ruling and is going to try to get in front of the judge who's going to be dealing with this case. All right? All right, I thank you. Thank you very much. And thank you.
Thank you, Judge.
You are the only participant.
This one? Madam Clerk is asking if we can do the Spanish interpreter case next. And that would be, is that Efraín Bonano Colón? Is that the one?
Refuse, Your Honor.
Is this where I sign with the judge?
Yes.
I'll just write it in just in case they don't know which, there you go. Okay. So the Spanish interpreter case of Efraín Bonano Colón, I'm sorry, you said he's refusing? Okay, and so I've only got one for him. In the case of Efraín Bonano Colón, I'm going to appoint the Office of the Public Defender to represent him.
We'll waive the appearance, Your Honor.
Thank you. I have reviewed the charging document and find probable cause. Count 1 is possession of alprazolam. Bond is set at $1,000. Count 2 is possession of drug paraphernalia. Bond is set at $100. Thank you.
Okay, I thought I was losing it.
Good
afternoon, Your Honor. This is Laura Bretaña, Spanish interpreter, previously sworn.
Good afternoon, Madam Interpreter. This is Judge Martinez. How are you doing?
Fine, and you?
Good, thank you. We have before us case number 2022 CF8047. And sir, can you please state your full name?
Marcelo Hernández Cruz.
Marcelo Hernandez Cruz.
And sir, you are here with regards to a charge of driving while license suspended or revoked. I have reviewed the charging affidavit, find probable cause. Bond is set at $2,500. I am appointing the Office of the Public Defender to represent you. The paperwork I have before me also indicates that you are out on bond with regards to a refusal to submit to a blood alcohol level test, also out on bond on a no valid driver's license test, and also out on bond on a DUI. With regards to those matters, I'm going to revoke the bonds on those cases and set this at a no bond status on each one. Do you understand what I have said, sir?
Sí, entiendo.
Yes, I understand.
All right. Thank you, sir. And now we do the 33s, or?
It should be one.
One more Spanish. Okay, thank you. Please state your name.
May honorable juez, buenas tardes, mi nombre es Wilfredo Lorenzana Resto.
Good afternoon, Your Honor. My name is Wilfredo Lorenzana Resto.
Good afternoon, sir.
Buenas tardes.
You are here on several matters. I'm going to start with the first arrest affidavit with regards to a charge of stolen property dealing in. I've reviewed the charging affidavit, find probable cause, bond is set at $2,500. Second affidavit for arrest has two counts. First is burglary of a dwelling or structure, conveyance armed.
In your honor,
Yes.
as to that count, I would argue no PC, as there is no mention of a weapon during the burglary in the arrest affidavit.
State?
State agrees, Your Honor. However, there is not any PC with regard to defendant being armed. There is probable cause with regard to burglary of a dwelling, Your Honor. So I would ask that you find probable cause for that.
No objection to that, Your Honor.
Mire, ¿podría hacerle una pregunta?
May I ask a question?
Sir, everything you say is being recorded, can be used against you.
Sí, señor.
And
Okay.
I would
Entiendo eso.
advise the client not to speak about the facts of the case. I am going to give you a form with the telephone number so you can speak one-on-one with your attorney about any defenses you may have.
Ok, solamente quería preguntarle sobre el discovery, la evidencia de video visual, porque yo nunca entré a la casa. Yo encontré las cosas fuera de la casa al lado del zafacón.
Again, I would advise.
I just wanted to ask about discovery because I never entered the house. I found the things outside by the trash.
Y lo que
Again,
necesito es el video.
I would advise you not speak about the facts of the case. Today's purpose is only to see if there's probable cause and set bond. Your defense, you can go over with your attorney one-on-one where it's not being recorded and can be used against you later.
Okay.
Okay.
With regards to the arrest affidavit, On the dwelling of structure or conveyance,
Yeah, but he has.
armed, there is no indication of armed. Does the state want an opportunity to review and see if an amended?
Not at this time, Your Honor. I looked to see what the appropriate statute would be, and I just need to confirm. But I believe just a simple burglary of a dwelling is,
I think they put in the wrong subsection.
yes,
That's why it printed out that way, but it's not like that. It's
correct, Your Honor, yes.
But let's do this. Is the state willing to orally amend
Yes, Your Honor.
to just the dwelling of a structure or conveyance at this time?
Yes, Your Honor.
And if the state is willing to convey, to modify at this time, I'm going to set bond on that at $1,000. And then the second count is larceny, grand theft, 750, less than 5,000, and that I would set at $250. Oh, Madam State is looking for that statute number.
Just need to confirm that I have the correct subsection. Madam Clerk.
Your Honor, so just to be clear, I'm trying to make sure I have the bond amounts. On the Dillon and stolen property, you set that at 2,500, correct?
Correct.
And then the armed, the burglary, you set at 1,000.
Uh-huh.
And the grand theft, you set at 250, but I think we're missing the resisting. I didn't catch that.
Yeah, that's coming next.
Okay.
I've got 3 different affidavits, so.
Okay, perfect.
Yes, Your Honor. With regard to the statute for burglary of a dwelling, it is 810.02, sub 3, sub A, Your Honor.
Sub 3, sub A.
Yes, Your Honor.
All right, thank you. Then we're going to deal with the third affidavit with a charge of resisting officer or obstructing without violence. Bond on that is set at $500.
Thank you, Your Honor.
All right,
I
thank you.
apologize, Your Honor.
I'm sorry?
With regard to the burglary of a dwelling, can I ask for a no return?
I'm going to require that you not return to the place where this incident took place. And the address on that is,
131 Pennsylvania Avenue.
thank you. Okay.
Una pregunta, ¿cómo puedo solicitar el abogado para hablar con él previamente?
I have a question. How can I get in touch with the attorney? How am I able to talk to him?
The paperwork that the assistant defender has handed you has the information for you to get a hold of the attorney. Okay?
Sí, señor. Sí, señor.
Yes, Your Honor.
All right, thank you, sir. Madam Interpreter, we have one more case.
We do? Who is this? Thank you.
Which one?
Who is it?
Wendy?
Thank you.
Please state your name.
Wendy Enid Fernandez Sanchez.
Wendy Eni Fernandez Sanchez.
You are represented by the Office of Defender. You are here with regards to a charge of driving a license suspended or revoked as a habitual traffic offender, and also a charge of resisting officer without violence. Counsel?
Yes, Your Honor. The offer from the state to resolve the case is an adjudication of guilt, credit time served, and court costs. Ms. Fernandez Sanchez would like to accept an enter a plea of no contest.
Being held on any other charges?
Not that I saw.
No me opongo.
I think they transferred this from a felony to a misdemeanor. I didn't see anything else. Do you see anything?
Double check.
No contest.
Oh, yes, yes.
She's still being held?
Looking on the jail website now, there appears to be a possession of cocaine, paraphernalia, and both of those are no bond.
And so I'm not going to accept the plea at this time. Based upon that information, I would prefer, I have no idea how this may affect any other matters that she's facing. And so I would prefer not to take care of this at this time. The indication from the state is that she's also being held on a no bond.
Yes, Your Honor. Just looking at the jail website, she does have at least 2 cases that are no bond, and there is a third case. Oh. No.
No, they,
I'm just looking at the case numbers. I apologize. No, it's the same case, but all
Yeah,
the
they were-
charges are no bond.
All right, and so at this point, I think the prudent thing to do is not accept the plea at this time.
I'll have the attorney set you for a plea downtown to resolve the misdemeanor case.
Okay.
Me pregunta, ¿no se me puede hacer las gestiones para abrirme la fianza?
I have a question. Are we able to do something about the bond right now so I can get a bond in the other cases?
That is a matter to pick up with the attorney that is representing you on the cases. Counsel, I would imagine that she has an attorney assigned, a public defender or a private attorney assigned with the other cases?
She has the public defender, Your Honor. I believe on all her cases.
And I would imagine that she would be interested in getting word to her attorney that the plea did not go forward today.
Yes, Your Honor, I'm going to let the attorney know so they can set it for a plea.
Okay, thank you. And
Let's see.
that way, Madam Interpreter, I know, is interpreting these matters to the client. Hopefully that helps inform her as to what is happening with the case.
Yes, Your Honor, I'm putting a note in for the attorney to speak with her. Yes, I will enter a plea of not guilty.
Division 62, pretrial conference, August 8th at 8:30, courtroom 12C.
¿Y qué vista es la que tienen para el 18?
I'm sorry.
And what kind of hearing do I have on the 18th?
What was that date? 18th, right?
The 18th.
Pre-trial.
Trial conference.
It's a pretrial conference, Madam Interpreter. All right, thank you, ma'am. Thank you, Madam. But before we let you go, do we have any other Spanish interpreter cases? No? All right, thank you, Madam Interpreter.
Thank you, Your Honor.
All right, if we can address the 33-day motions. And what is this document? Oh, that's the 33s.
Madam Clerk, were the 33-day motions, were they put in alphabetical order? Oh,
I put them on the way that they sent them. Okay.
All right, you all ready to go forward?
yes, Your Honor.
Defense?
Yes, Your Honor.
Okay, let's start with Michelle Shannon Hudson, case number 2022CF6696AO. State?
I'm sorry, Your Honor, but just give me a moment.
No
Just give me the
problem.
case number one more time, please.
Surely. 2022CF6696AO. This particular individual, no, that's only one. Okay, got it.
What is the name that you have for that?
I I have Michelle Shannon Hudson,
But you have it as 6696?
6696AO.
One moment, Your Honor. That's not the case number that I had.
Okay.
All right, Your Honor, just bear with me just one moment.
It's okay.
And information has not been filed at this time, Your Honor.
Granted.
It has to be granted as an information has not been filed at this time.
Okay. And therefore, in the case of Hudson, it's granted. Next I have is Maynor Zeron, Zeron, 2022 CF 6479AO.
Granted, notice of non-filing.
It's granted. Then we have Timbrel Battle, 2022 CF 1509AO.
Denied, information was filed.
We have Arthur Danton, 2021 CF 11970.
Granted, notice of non-filing.
Hanson Harrison, 2022 CF 5238.
Denied, information was filed.
Oh, I've got another one for Michelle Hudson, 2022 CF 3306.
Granted, notice of non-filing.
Is that okay the way I'm doing it, or do you want me to circle it? Patrick Donald, it says 22 CF 6566AO.
Granted, notice of non-filing.
Diego Mejia, 22 CF 6563.
Granted, notice of non-filing.
Jadarius Martin, 22 CF 5596.
Granted, notice of non-filing.
Avery Spirit, 22 CF 6719.
Denied, and information was filed.
Tanel Giles, 22 CF 6756.
Granted, notice of non-filing.
Jonathan Harris, 22 CF 6665.
Denied, and information was filed.
Elvin Varnador, 22 CF 5932.
Denied, and information was filed.
Albert Ayala, 22 CF 6673.
Denied, and information was filed.
Jose Luis Rosado Almodovar, 22 CF 6749.
Denied, and information was filed.
Erica Lovesmith, 22 CF 6678.
Granted, notice of non-filing.
Timothy Paul Jones, 22 CF 6373.
Denied, and information was filed.
Errol Birch, 22 CF 6698.
Granted, notice of non-filing.
Howard Edward Jones, 22CF 3546.
Granted, notice of non-filing.
Teresa Jackson, 22CF 6628.
Denied, information was filed.
Cleveland Mayfield, 22CF 6710.
This case is premature, Your Honor. His 33rd day is not until tomorrow.
Your Honor, we are allowed to file our 33-day motions on the 30th day, which states to be released on the 33rd day. However, defense has no objection to just having it reset for in the morning, Your Honor, since the 33rd day is in the morning.
So the state has made no charging decision at this time?
Not at this time, Your Honor.
All right, can we recall that tomorrow? Then we have Julio Acosta Diaz, 22CF 6785.
Granted, notice of non-filing.
DeAndre Jackson, 22CF 5161.
Granted, notice of non-filing.
Tehran Thomas, 22CF 6612.
Granted, notice of non-filing.
Neil Paul Morrison Jr., 22CF 6322.
Granted, notice of non-filing.
Michael DeVoris Bridges, 22CF 3991.
Granted, notice of non-filing.
That's all I have. Did we get through everyone?
Yes.
All right, thank you. Everyone ready to go forward, or anyone need a break, or everyone's cool?
No, Your Honor.
Madam Clerk may need a minute there. No, I'm okay. You're okay? Okay, so what are we doing next?
The angel arraignment, you can take the paper clip off.
Okay.
Now you have a Natasha Jean. She's medical.
Okay. Natasha Jean, I'm appointing the Office of the Public Defender to represent them. This is with regards to an underlying charge of driving with license suspended or revoked with knowledge, noted as having one prior.
I will enter denial. Sorry. It's not guilty, Your Honor.
All right, thank you. Yes, right, we're appointing the public defender on that. What does it say, 6 days FTA? Failure to appear case on that, got it, thank you.
Division 85, pretrial conference, August 22nd at 9 o'clock, courtroom 4A.
Please state your name, sir.
We have the next one, Stephen Stewart, Your Honor. He's medical also.
Okay, in the case of Stephen Stewart, he's represented by the Office of the Public Defender. This is with regards to charge of moving traffic violation, driving while license suspended or revoked.
I will waive and enter a plea of not guilty, Your Honor.
Division 61, pretrial conference, August 4th at 1:30, courtroom 7C.
Is that for both cases?
Well, yeah, I just realized he's got a second one, which is a charge of reckless driving, also represented by the Office of the Public Defender. So I would put these two together to be handled together.
Okay, both are set for the same date, Judge.
Thank you.
Thank you.
Then I have a,
Lockhart.
yes.
She's medical also.
All right, so with regards to the case of Deshae Lockhart, she's represented by the Office of the Public Defender. This is a matter of a trespass on property other than structure or conveyance.
I will waive and enter a plea of not guilty, Your Honor.
All right, thank you.
Division 62, pretrial conference, August 8th at 8:30, courtroom 12C.
All right, please state your name, sir.
Sims.
Your name, please.
Sims. My last name Sims.
Sims. And what's your first name, please?
Then I'm in the morning 2P68. Rashawn.
All right. You are represented by the Office of the Public Defender. This is with regards to a charge of petty theft, second degree, noted as having a previous theft conviction.
I will enter a plea of not guilty, Your Honor.
All right.
Division 83, pretrial conference, August 1st at 8:30, courtroom 6C.
Thank you, sir. Everything I have, right?
Yes.
You want this?
All right, Your Honor, Ms. George, Zagetta. She's mental health.
Okay. And so Sagita Lynn George, I will appoint the Office of the Public Defender to represent her. She's here on a charge of trespass on property after warning. I've read the charging affidavit. I find probable cause.
What's wrong with her?
Okay.
Bond is set at
Your Honor.
$500.
I didn't, based on my, she's pled before. There's an offer to resolve both cases. Could we see if she could come to court tomorrow? If not, then I'll just waive the appearance.
Oh, I don't mind, Your Honor.
All right.
Thank you.
We'll reset for tomorrow on Ms. Sagita.
Mental health.
Mental health.
Jarvis Jacobs is medical.
Okay. In the case of Jarvis Javon Jacobs, count 1 is assault, count 2 is trespass on property after warning, count 3 is resisting officer without violence. I've reviewed the charging affidavit, find probable cause. I'm appointing the Office of the Public Defender to represent him.
Your Honor, I will waive his appearance. In addition to whatever bond you set, I would just ask that he be screened for mental health pretrial release because I know there was a mention of him being mentally unstable.
State, any comment?
No objection, Your Honor.
Let me just double check this sheet over here.
That's weird.
All right, and so count 1, bond is set at 500, count 2, bond is set at 100, count 3, bond is set at 100, or mental health pretrial release if he qualifies.
Thank you, Your Honor.
Can I also ask for a no return to the property, Your Honor?
I'm going to require that he not return to the premises where this incident took place, which is the 5300 Cinder Lane Parkway Apartments, otherwise known as the Aventura Apartments. That's not him. Yeah. Okay, thank you. Your name, sir?
Scott Patterson.
And sir, you are here on a charge of battery. I've reviewed the charging affidavit. Find probable cause. I'm appointing the Office of the Public Defender to represent you. Bond is set at $500. And- All right, State Defense, anything else?
No contact with the victim?
I'm going to require that you have no contact with the alleged victim in this case. Anything else?
No, Your Honor.
Nothing from defense, Your Honor.
All right, thank you. Thank you, sir. Please state your name.
John Randall Sanders.
And,
Is this going to be a plea?
yes, Your Honor. The offer from the state is an adjudication of guilt, 3 days in the Orange County Jail with credit for time served and no return to 523 South Dillard Street. Mr. Sanders would like to accept the state's offer and enter a plea of no contest.
All right, and the state, is that the offer?
Yes, Your Honor.
please swear him in?
Sir, can you raise your right hand?
Thank
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
Thank you.
And, sir, can you please state your full name?
State my full name?
Yes, sir.
John Randall Sanders.
And, sir, let the record reflect that the plea form was signed in open court. Have you reviewed this plea form?
No, sir.
All right.
We didn't review it, Your Honor. We went over it
Oh,
together.
Did you go over the plea form with your attorney?
Yes.
And do you
Yes,
understand?
sir.
Do you understand the rights that appear on the front of the plea form?
The
What did he
right.
say?
Do you understand the rights that's on the plea form?
Yes,
The
sir.
ones we went
You
over.
understand you're giving up those rights by entering a plea here today?
Yes, sir.
You understand the maximum and minimum penalties for the charge you are pleading here today on?
Do I understand?
Yes, did you go over,
Charge?
did you go over that with your attorney?
Yes, sir.
Are you under the influence of any alcohol, drugs, or medication that might affect your thinking here today?
Not at all.
You suffer from any type of mental condition or disease that might affect your ability to think clearly?
No, sir.
You understand that entering a plea of guilty or no contest to this charge can lead to deportation from the United States if you are not a legal citizen of the United States?
Yes, I do.
Are you satisfied with the services of your attorney?
I certainly am.
With regards to the charge of trespassing, failure to leave property upon order by the owner, with regards to an incident of July 11th, 2022, how do you plead?
No contest.
I accept the plea of no contest, find you are alert and intelligent, understand the rights and the penalties associated with the charge. You are entering the plea of your own free will, and there are sufficient facts to accept the plea. At this point, I'm going to adjudicate you guilty of the charge. I'm going to require that you serve 3 days Orange County Jail, give you credit for 3 days time served.
That's 2 days, Your Honor.
2 days, Your Honor.
2 days, I'm sorry, 2 days Orange County Jail with credit for 2 days time served. I'm going to require that you not return to the place where this incident took place for a period of 1 year, that being the Sun's Market located at 523 South Dillard Street. I'm going to impose upon you all applicable court costs and fees and give you 1 year to pay on those. You have 30 days to appeal the decision of the court in writing. If you cannot afford an attorney for appellate purposes, one can be appointed for you if you qualify. Thank you, sir.
Okay.
Robert Scott, behavior, Your Honor.
Okay.
Your Honor, I will waive the appearance.
Thank you. I'm appointing the Office of the Public Defender to represent him. This is with regards to count 1 charge of resisting officer without violence, count 2 petty theft. I've reviewed the charging affidavit, find probable cause. Bond on count 1 is $500. Bond on count 2 is $250. He is also out on bond with regards to case number 22MM4660. I'm going to revoke on that and set that at a no bond status.
No, Your Honor, I think the case number you just gave is for the,
I'm so sorry. It would be, I'm looking at the wrong place for the number. Thank you. It's 2022 CF3412 AO.
thank you.
Thank you. Please state your name.
Jakira Smith Geddes.
You are here on a charge of battery. I've reviewed the charging affidavit, find probable cause. I am appointing the Office of the Public Defender to represent you. Bond is set at $500. I'm going to require that you have no contact with the alleged victim in the case and that you not return to the place where this incident took place at 5449 Pine Chase Drive. Anything else, state or defense?
No, Your Honor.
No, Your Honor.
All right, thank you very much, ma'am.
That's it.
That's it.
Mm-hmm.
Please state your name.
Jonathan Bellamy.
All right. And, sir, you are here on a warrant with regards to a failure to appear on an underlying charge of trespass on property. I'm appointing the Office of the Public Defender to represent you.
Your Honor, the offer from the state is an adjudication of guilt. Credit time served, no return to 2921 West Concord Street. There's also a cost of investigation in the amount of $179.08 to the Orlando Police Department. Mr. Bellamy would like to accept and enter a plea of no contest.
And state, is that the offer?
Yes, Your Honor.
And he's not being held on anything else, correct? Okay, thank you. All right, and can you please swear him in?
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
Thank you.
And thank you. How much time served is he showing? 16? Thank you. And let the record reflect the plea form was signed in open court. And sir, did you review this plea form with your attorney?
Yes, sir.
You understand the rights that appear on the front of the form?
Yes, sir.
You understand you are giving up those rights by entering a plea here today?
Yes, sir.
You understand the maximum and minimum penalties for the charge you're pleading here today on?
Yes, sir.
Are you entering the plea of your own free will?
Yes, sir.
Under the influence of any alcohol, drugs, or medication that might affect your thinking here today?
No, sir.
You suffer from any type of mental condition or disease that might affect your ability to think clearly?
No, sir.
You understand that entering a plea of guilty or no contest to this charge can lead to deportation from the United States
Yes, sir.
if you are not a legal citizen of the United States?
Yes, sir.
Are you satisfied with the services of your attorney?
Yes, sir.
With regards to the charge of trespass on property from an incident, let me see. It looks like it was early July of 2022. How do you plead?
No contest.
I accept the plea of no contest, find you are alert and intelligent, understand the rights and the penalties associated with the charge. You are entering the plea of your own free will, and there are sufficient facts to accept the plea. At this point, I'm going to adjudicate you guilty of the offense. I'm going to require that you serve 16 days. Orange County Jail give you credit for 16 days time served. I'm going to require that you not return to the place where this incident took place, which is 2921 West Concord. I'm going to impose upon you all applicable court costs and fees, in addition to cost of investigation to the Orlando Police Department in the amount of $179.08. We will put the financial obligations together and require that you pay them within a 1-year period of time. You have 30 days to appeal the decision of the court in writing. If you cannot afford an attorney for appellate purposes, one can be appointed for you if you qualify. Thank you, sir. Please state your name.
Magdala Faith Jean.
I have just a moment, Your Honor.
Yes.
Thank you, Your Honor.
Is there anything you need to make the court aware of, or?
No, Your Honor, it was just that she was one of the inmates that wasn't brought up when I spoke to everyone else. So I was just going over the.
Madam Clerk is indicating that she may have conflict counsel appointed.
Oh, you have private?
Joshua Adams.
So you just come.
I missed it.
Yes, the file is indicating she's represented by Joshua Adams.
Did you get that? I didn't see it. No.
I don't look.
Court appointed attorney appointed July 8th of this year.
Oh, I see. Yeah, they closed it out. It's regional conflict. I'm
All
sorry.
right. And so,
We can't plea it because you have regional conflict counsel.
just to let you know, you are here on a matter
Hold on, let me see.
of a warrant failure to appear on a charge of petty theft of $100 or more. The judge has set that at a no bond status. Thank you.
Can I just a moment, Your Honor, just so she knows? Order. Oh, okay. Because I don't think she knows. It just occurred. on the 6th, so I was just trying to see. I don't even have a phone number for him. So. Thank you, Your Honor.
You're welcome. Please state your name.
Johnson.
I'm so sorry. Please repeat that.
Christopher Johnson.
You're here with regards to a warrant on a trespass on property or other structure other than conveyance. This is with regards to a failure to appear, and the judge set that at a $2,000 bond. I'm appointing the Office of the Public Defender to represent you.
Thank you, Your Honor. Bond, it's 200 for the bail bond. But that's the, it's really. That's the only thing I can see. So I can't tell you until that gets resolved. So call the attorney. She's gonna, well, they'll see you tomorrow anyway.
Please state your name.
Kevin Rosen.
Sir, you're here with regards to a warrant for a failure to appear on a charge of soliciting without permit. I'm appointing the Office of the Public Defender to represent you.
And Your Honor, there was an offer of a withhold of adjudication, credit time served to resolve the soliciting charge, the underlining charge. Mr. Rosen would like to accept and enter a plea of no contest.
And state, is that the offer?
Yes, Your Honor.
Fine.
All right. And just, can you please swear him in?
Yes, sir. Oh, I don't know how many hours it's going to
You have enough to do. I'll swear him in.
Oh, I think he's fine. I was just waiting for him to finish.
Okay.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Thank you.
Can you please state your full name?
Kevin G. Rosen.
Thank you. And sir, did you review this plea form with the attorney?
Yes, sir.
Do you understand the rights that appear on the front of the plea form?
Yes, Your Honor.
Do you understand you're giving up those rights by entering a plea here today?
Yes, Your
Do
Honor.
you understand the maximum and minimum penalties for the charge you're pleading here today on?
Yes, Your Honor.
Are you entering the plea of your own free will?
Yes, Your Honor.
Are you under the influence of any alcohol, drugs, or medication that might affect your thinking here today?
No.
Do you suffer from any type of mental condition or disease that might affect your ability to think clearly here?
No, Your Honor.
You understand that entering a plea of guilty or no contest to this charge can lead to deportation from the United States if you are not a legal citizen of the United States?
Yes.
Are you satisfied with the services of your attorney?
Yes, Your Honor.
With regards to the charge of soliciting without a permit, how do you plead?
No contest.
I accept a plea of no contest, find you are alert and intelligent, you understand the rights and the penalties associated with the charge, you are entering the plea of your own free will,
Yes.
and there are sufficient facts to accept the plea. At this point, I'm going to withhold adjudication on the charge. I'm going to impose upon you all applicable costs and fees, and we're going to give you 1 year to pay on those. You have 30 days to appeal the decision of the court in writing. If you cannot afford an attorney for appellate purposes, one could be appointed for you if you qualify. Thank you.
Thank you, Your Honor.
Your Honor, do you know the credit time served?
I'm not giving him credit for time served. Let me, if you all will approach, I'll let you know how that works.
Oh, it's not for me, Your Honor. I understand.
This is, if you all will approach.
Okay.
Dennis Hoover.
And, Your Honor, Mr. Hoover, the state is offering a withhold and court costs as to this disorderly conduct, and he would like to accept and enter a plea of no contest.
I'm showing that he's out on bond on a possession of cocaine.
He is, Your Honor. I would ask that, given that he is resolving the disorderly, that you take no action on the out on bond.
My concern is I don't know how pleading on this case may affect his possession of cocaine charge?
Generally does not, Your Honor, unless you,
And that's the key word, generally. I don't want to, I mean, I would rather that this act in a more definite matter. If the state is able to tell me definitively that there will be absolutely no consequences, point-wise or anything, based upon his record. But at this point, I'm hesitant. It would perhaps make more sense to me if he wants to plead with the proper division on the possession of cocaine, and I'm sure that judge would be more than willing to take care of the disorderly conduct at that time as well.
I don't know how long he's going to be in here. Let's see.
formal charges have been filed and pretrial is set for August 17th on the felony.
Okay. Your Honor, my client understands your position. However, he's willing to take that chance and he would like to accept the state's offer here today. He just got into a home. He's going to lose his home.
Just to let Mr. Hoover know as well that he has no idea what I'm going to be doing with regards to the ROR he has on the possession of cocaine charge. He doesn't know if I'm going to revoke it, leave it at ROR, put it at no bond, or set a bond on it.
So, Your Honor, I would just argue that normally when we have the city and county ordinance cases, our clients usually plea to those cases at IAs, and then because they pled to the new law that no action is taken on the out on bond, he has no money for bond, Your Honor. I just point to the fact that he just recently got into a place. He's a military veteran.
Is there any way perhaps he may be a candidate for Veterans Court?
Yes, Your Honor, but that would be done with his, I believe his drug offense. His possession of cocaine, I believe the veteran, he may qualify for veteran court for the possession of cocaine. Let's see. I'm just checking to see if there were any. Yeah. And it just says he's set, he wants to plead the cocaine out.
I understand, but I just want to make sure that Mr. Hoover understands that we haven't addressed yet the matter with regards to the possession of cocaine and his ROR. And in deciding what to do with that, I am looking at the information I have provided with regards to his prior history.
All right.
No, at all.
He can't afford anything, Your Honor, so he's going to be held here. If you revoke the out on bond, or even if you don't accept the plea and set a bond on the disorderly.
Can you all please approach for a moment? I'm just going to go off record here for a moment, and please let me know if you want to be on record. right, and they can hear me? All right. Good morning. For the record, I am Judge Wilfredo Martinez. If you will please state your names for the record, counsel.
Brenda Eugene on behalf of the State Attorney's Office.
Letitia George on behalf of the Office of the Public Defender.
Thank you. And, sir, can you please state your full name?
Tá, e qual é o seu nome completo?
Fabiana Farias de Paula.
And, sir, it indicates on paperwork that I just reviewed that you may prefer Spanish interpreter for initial appearances. Do you feel more comfortable in Portuguese, Spanish? Which language do you
E o
prefer?
senhor gostaria, o senhor preferiria qual intérprete, de português ou espanhol?
I'm not hearing interpretation.
I really can't hear him, your judge.
Okay.
Português.
Portuguese.
All right, thank you. Sir,
Obrigada.
you are here on 2 counts. Count 1 is aggravated battery on a pregnant person, domestic violence related. Count 2 is battery, felony.
Tá, então o senhor está aqui por 2 contas, né? O primeiro é de ter batido numa pessoa de estar grávida e a segunda é de bater em alguém.
This is a warrant arrest.
Tá, esse daqui foi pedido para ser de aprisionamento.
I'm appointing the Office of the Public Defender to represent you.
Tá, e tem assistente, advogado público que vai defendê-lo.
I see that we have someone in the booth.
E eu vejo que tem mais alguém aqui também.
Does the victim need the interpreter?
I don't know, but probably.
Do you speak English or you need Portuguese interpreter?
Português. Português.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
E você afirma que o testemunho que você vai dar é toda a verdade, nada além da verdade, e assim lhe ajude Deus.
Sim.
Please state your name for the record.
E qual é o seu nome completo?
Fabiana Farias de Paula.
Counsel, do you wish to inquire?
Thank you.
Obrigada. O senhor quer fazer alguma pergunta?
Não.
Good morning.
Não.
Yeah.
Não. Não, nenhuma pergunta.
I don't have any questions.
Okay, I'm going to, this individual is an attorney that represents the Office of the State Attorney.
Ah, essa pessoa é advogado que vai representar o advogado do Estado.
They are the prosecutorial entity in the court system.
Eles são os promotores no sistema da corte.
They're the ones that are looking at bringing criminal charges against the gentleman standing here.
É eles que vão tentar, né, fazer as acusações para essa pessoa que está aqui.
I'm giving this attorney an opportunity to ask you questions since you are present here today, and it appears that you want to let the court know something.
Tá, e eu vou deixar que esse advogado faça as perguntas para a senhora hoje, porque parece que a senhora quer dizer alguma coisa hoje.
All right, so go ahead, counsel.
Thank you. Ma'am, how do you know the defendant?
Sorry?
Tá, como que a senhora conhece o réu?
A gente se conheceu aqui quando eu estava passeando e ele também estava passeando na praia.
We met here when we were both vacationing and we met at the beach.
Do you live together?
Yes.
Vocês moram juntos?
While this case is pending, do you want to continue living together?
Enquanto esse caso está pendente, você quer continuar morando com ele?
Eu acho que sim, porque como casal a gente não funciona mais. Nós passamos 4 anos muito bem mas como pais, nós somos muito bons.
I believe that yes, we do. We lived together as a couple for 4 years, but that doesn't work anymore. But we are great parents.
I apologize, that didn't answer my question. Do you still want to live with him?
Então a senhora quer continuar morando com ele?
Eu acho que sim, porque eu acredito que agora eu acho que como foi a primeira vez, eu não acredito que isso vá se repetir de novo, dadas as circunstâncias de tudo.
Yes, I believe that.
Eu não queria que ele
Yeah.
se afastasse das filhas, porque, como eu falei, como pai, ele é muito bom.
I think yes, because this is the first time, and I don't think this will ever happen again. And I don't want him to be away from his daughters, and he's a great father.
Are you afraid of him?
A senhora tem medo dele?
Hoje em dia, não tenho medo. Eu só tive medo naquele dia.
nowadays.
Foi o único dia em que eu realmente tive medo, porque durante esses 4 anos eu nunca tive medo. Nunca aconteceu nada.
No, I've only been afraid of him once, which was that day, and we've been together for 4 years, and it has never happened.
Were drugs or alcohol involved in this incident?
E teve drogas e teve uso de drogas e bebidas alcoólicas nesse dia do incidente?
Não.
Não.
Thank you. I have no further questions.
Obrigada. Não tem mais nenhuma pergunta.
The attorney sitting at the other table represents the Office of the Public Defender. They are attorneys who help defend individuals who have allegedly committed crimes. I'm going to give her Go ahead, interpreter.
Então, o outro advogado é quem vai defender o réu.
I'm going to give her an opportunity to ask you questions if she wishes. Counsel, do you wish to ask any questions?
No questions, Your Honor.
Eu vou dar a oportunidade a ela fazer perguntas para a senhora. A senhora tem alguma pergunta? Eu não tenho nenhuma pergunta.
All right, according to the warrant, count 1 on aggravated battery on a pregnant person, bond is set at $5,000. Count 2, felony battery, domestic battery by strangulation, that was set at a no bond status.
Tá, então no primeiro, bater numa pessoa que está grávida, eu vou colocar o preço de $5.000 na fiança. E na segunda, que é a violência doméstica por estrangulamento, nós ainda não estipulamos nenhum preço.
Your Honor, he is entitled to a bond, so I'd ask that you set a bond on the battery.
All right.
Tá, e ele tem, ele pode ter uma fiança e eles colocaram a fiança no acusamento de ter batido.
Okay. State any comment?
No, Your Honor.
O Estado tem algum comentário? Não?
All right, I'm setting bond at $2,500. You are to have no contact whatsoever with the victim in this case.
Então a fiança vai ser de $2.500 e o senhor não pode ter nenhum contato com a vítima neste caso.
That is no contact whatsoever, which means that you cannot speak to her in person.
Tá, não tem contato nenhum, o senhor não pode conversar com ela em pessoa.
You may not contact her by telephone,
O senhor não pode entrar em contato com ela por telefone,
text, or email,
mensagem de texto ou e-mail,
or any type of social network platform.
ou qualquer tipo de plataforma de mídia.
You may not have another person try to communicate on your behalf with her.
O senhor não pode tentar entrar em contato com ela por outra pessoa.
And listen carefully to this next instruction. You are not
Preste
to
atenção nessa
accept
próxima
any
instrução.
communications from her.
O senhor não pode aceitar nenhum tipo de comunicação vindo dela.
You are to maintain a separate residence.
Vocês têm que morar em lugares diferentes.
You may return one time to the residence with the assistance of law enforcement to retrieve personal possessions.
O senhor pode voltar para a residência uma vez com um oficial da justiça para pegar as suas pertences.
You are to consume or possess no alcohol or non-prescription drugs.
O senhor não pode tomar bebidas alcoólicas ou fazer algum tipo de droga.
You are to control nor possess any weapons or firearms.
O senhor não pode ter nenhum tipo de armas ou revólveres, nada disso.
Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release.
Se o senhor tiver algum tipo de armas que pertencem ao senhor, o senhor tem que dar para os oficiais quando o senhor for liberado.
You are to maintain a distance of at least 500 feet away from the victim.
O senhor tem que manter pelo menos uma distância de 500 pés da vítima.
500 feet away from her residence.
500 pés da residência dela.
From her vehicle.
Do carro dela.
From her place of employment.
Da onde ela trabalha.
Her place of worship.
Da onde que ela vai fazer alguma coisa religiosa.
Educational institutions if she is studying.
Qualquer lugar onde ela estuda.
I think I've addressed all issues. Thank you.
Então, acho que era só isso. Obrigada.
Anything else, State Defense?
Nothing from the state.
If you have a question, I would prefer that you run it by the attorney. I think he speaks a little English.
Tá, se eu tiver alguma pergunta, faça para o advogado.
There you go. Thank you. In the case, I forgot to ask the question, counsel. Does he, if he has a passport, I'm also going to require that he surrender his passport within, well, that he surrender his passport before. Is there someone who can get his passport and surrender it before he is released?
Tá, eu também gostaria de pegar o passaporte. Tem alguém que possa pegar o passaporte dele antes dele ser liberado?
Can I
States
say
she has
something?
his passport, Your Honor.
Yeah.
Okay, and so I'm going to require that his passport be handed in to the state attorney's office. I think that's usually who gets it, no? No? Who gets it? The clerk's office. Thank you for the correction. And where would she find the clerk's office? Where would she? Okay. All right. Madam Clerk is explaining to me that you can bring the passport to the jail and hand it over to the clerk's office.
I have the
jail.
passport today.
Okay, good. So you can go after here. She can go downstairs. Is it the first floor? Oh, okay. If Madam Clerk, well, that's a lot for them to interpret, huh? Madam Clerk has indicated that if you can go now, do you have it on your possession?
Yeah, but in outside, in the lock.
If you can go get it, Madam Clerk's, and come back here? And come back here,
Like now or no?
yeah, like now, and she'll process it, at least that part will be done with.
Okay, just need ask something. I just need to ask something. And about the baby, he can grab the baby with another, without me, but with another person? Or
You're asking if he can have contact with the child?
just with the child?
Okay, I am
Without
not
me.
addressing that issue right now.
Okay,
I'm just addressing the criminal issue,
okay.
all right? And so I'm not, I don't believe the Department of Children and Families is involved in this yet. Is that correct, State?
I did not see an indication about
Right.
that, Your Honor.
And so I'm not addressing that issue,
Okay.
okay? Just the two of you cannot have contact,
Mhm, I
can't
know.
communicate at all.
I know, okay.
All right, thank you.
Your Honor, as far as count 2 is concerned, since count 1 is set at 5,000, I was gonna ask for count 2 to be treated as a subsidiary or at least a $500 bond. He has no criminal history, no failures to appear. He's been here for over a year, so I'm asking that you consider reducing count 2.
Thank you for the
500.
request. That was set by a warrant. And I believe that's going to, this case is going to go to the judge that signed the warrant. So I am going to defer to the warrant.
You have to see if your sister.
All right.
Sister will help you. If not, we can, oh, count 2. Mind, Your Honor, count 2 didn't have a bond amount.
It was set at no bond.
And then you said it, no, I think you set a bond of 2,500.
Correct. So, but on the warrant, it was set at no bond. So I'm leaving count 1 at a $5,000 bond. That was set by the warrant judge. And then count 2, I have granted a bond and conditions as I stated prior.
I need a translator for this last part, just for make sure.
I didn't hear.
Sorry, I need the translator for the last part, just for make sure about the bond. Please.
Okay, and let me see where the bond condition was. I believe I said bond at $2,500, no contact with you whatsoever. Correct, thank you, directly or indirectly. No telephone contact. And I'm sorry, Madam Interpreter, please continue.
Ok. Então, ele colocou a fiança de $2.500 e não pode ter contato nenhum com a senhora.
Entendi.
And that means no
Okay,
contact by telephone, text, email.
Okay. Okay.
Madam Interpreter?
Não pode ter contato por telefone, por mensagem de texto, e-mail.
No contact by a third person?
Okay.
Nenhuma outra pessoa pode entrar em contato por ele.
Does that answer your question?
Yes. Yes, thank you.
Okay. Correct. Well, no, count 1 is 5,000, count 2 is 2,500.
That's fine. You can pick it up at any time.
Is that, I just want to make sure that your questions are answered. Did I answer
No,
your
that's not.
questions? And I'm referring to the individual in the booth.
No, it's
Eu
fine.
respondi suas perguntas.
Okay,
Thank you.
thank you. All right, go ahead, counsel.
Hi, good morning, Your Honor. Attorney Ashley Parker. I'm here on behalf of Mr. Bruce.
All right, and sir, have you filed an appearance on behalf of Mr. Bruce?
We have not, Your Honor. The case number wasn't known to my office until we literally got here this morning because it came in on a warrant.
All right, and will you put on the record what type of representation you're doing? Are you doing a representation only for today? Are you going to be involved in this case completely?
No, Your Honor, we're going to be involved in this case completely. It's not a limited notice.
All right.
I'll have that filed by the end of the day today.
All right. Thank you. Go ahead, counsel.
Judge, Mr. Bruce is here based on a warrant. He was informed of the warrant yesterday. When he was informed, he drove over from Tampa and turned himself in last night. The charge is domestic battery by strangulation. I believe that the alleged victim is here. We're just asking the court to exercise its discretion and grant Mr. Bruce a bond in the amount of $1,500 with standard conditions of release. We would ask the court to allow Mr. Bruce to have contact with the alleged victim in this case, just that it be no hostile contact.
All right, and I do see an individual in the booth. Can you please swear her in?
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Please state your name for the record.
Raven Moore.
All right. Good morning. The Assistant State Attorney is going to have an opportunity to ask you questions.
Okay.
Good morning, ma'am.
Morning.
How do you know the defendant?
We're dating currently.
You live together.
No.
While this case is pending, would you like to have contact with him?
Yes, he's never done this before, ever.
Okay. Were drugs or alcohol involved in this incident?
Not on his behalf, but on my behalf, I was on medication due to something that I prefer not to disclose.
Okay. I have no further questions at this time. Thank you.
Any questions, counsel?
Ms. Moore, are you in fear of Mr. Bruce?
No, I'm not in fear.
And just to reiterate, you would like for the judge to allow Mr. Bruce to have contact with you while this case is proceeding?
Yes, like I said, I'm not in fear of my life or anything. He's never done this before at all, so I don't fear for my life, no.
Okay, nothing further, Judge.
Thank you. Anything else, State?
Nothing from the state. Thank you.
All right. This is also a warrant arrest. The judge indicated on the warrant that it may be modified by the first appearance judge. I'm going to set bond at $5,000. I'm going to require that you have no contact whatsoever with the alleged victim in the case. That means that you may not speak to her in person. You may not contact her by telephone, by texting, emailing, any type of communication, be it on a social media platform, no contact whatsoever. And you cannot even try to contact her by way of a third person. So you cannot ask someone else to communicate with her on your behalf. That also means that you may not accept any communications from her. And so please understand that, for example, if you were to try to telephone you, if you respond to that, that can be seen as a violation of my order, okay? I'm also going to require that you possess or consume no alcohol or non-prescription drugs. I'm going to require that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. I'm going to require that you maintain a distance of at least 500 feet away from the alleged victim in the case. That's 500 feet away from her person, from her residence, her vehicle, her place of employ, house of worship, if she is attending school, any educational institution, and any stores that you know that she frequents. Okay? Any questions, counsel?
No questions, Judge.
All right, thank you. Thank you, counsel. Is the Portuguese interpreter still on the telephone? There's no response, so I think they're gone.
Good morning, Your Honor. This is Ricardo Morales, Spanish interpreter. I have been previously sworn.
Good morning. Can you please state your name?
My apologies, Your Honor. I cannot, the interpreter cannot understand the defendant.
Mi nombre es María García Rivas.
Maria Garcia Rivas.
Ujú.
You are here on a charge of battery, domestic violence related. I have reviewed the charging affidavit and find probable cause. I am appointing the Office of the Public Defender to represent you at this time.
Ujú.
I am setting bond at $1,500. You are to have no contact whatsoever with the alleged victim in the case. That means that you cannot talk to them in person, you cannot text, email, or try to communicate via any social media platform. And you cannot have another individual try to get a message to him on your behalf. You are also not to receive any attempt at communication from them to you. You are to maintain a separate residence from the alleged victim. You are to consume or possess no alcohol or non-prescription drugs. You are to possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. You are to maintain a distance of at least 500 feet away from the alleged victim. That also includes 500 feet away from their residence, their vehicle, their place of employment, place of worship, their place of education if they are attending a school, and any stores that you know that they frequent. You may return one time with the assistance of law enforcement to the residence to pick up personal belongings. Any questions, defense?
Your Honor, she has no criminal history. I was gonna ask for pretrial release, never been in trouble. No failures to appear, no indication she wouldn't show up for court, and she qualifies for pretrial release, so I would ask for pretrial release in this case.
State?
Objection.
Well, we don't have an alleged victim here. And that, I think I would feel more comfortable if we had some type of input from the victim in that response. Let me see, does the paperwork indicate victim contact not made? I don't know how it works in this jurisdiction, but if contact can be made with the victim and the victim has no objection, then the court would agree to pretrial release.
Here, Your Honor, the court can grant pretrial release whether the victim is contacted or agrees with release conditions.
Yeah, and I'm sorry, yesterday I was informed by the attorneys here, by the state and the defense, that the custom was, and again, I'm trying to abide by local customs, but I was informed that the local custom was that if the individual alleged victim did not appear, that usually pretrial release would not be granted. Now, I may have misunderstood.
No, Your Honor, we were referring to contact. If the victim doesn't appear, then we are not allowed to give contact because the victim must appear in court and state that they would like contact with the alleged defendant. However, based on a person's record and their history, the court can grant pretrial release whether or not.
No, go ahead. I'm sorry. It's just that the other person showed up with the passport.
Oh, okay.
Yeah. I'm sorry, counsel. Please continue.
The court can still grant pretrial release whether or not the victim appears for court, Your Honor.
State, any comment?
No, Your Honor, that is correct. It is up to the court as to whether or not to allow a pretrial release, regardless of whether or not the victim is present. It is only with regard to contact that we do have the victim have input.
Okay. Now, here then, pretrial release, and counsel can explain this to you, Ms. Garcia Rivas, will entails some type of supervision of you. And so I don't know if you would prefer a monetary amount for a bond or the pretrial release. That is something you can talk to the attorney about. And so in this case, I'll say either $1,500 bond or pretrial release. So either one, but I think that before I put you on pretrial release, it would be important for you to understand what pretrial release means, okay? And that's a conversation you can have with the attorney. And then you can decide if you want to post a money bond or if you want to do the pretrial release, okay? All right, thank you.
Yes. Your Honor, may the interpreter respectfully ask for the case number?
Yes. It is 2022 MM 4662.
Thank you, Your Honor.
Correct.
Mm-hmm.
Yeah.
Good morning, sir. Please state your name.
Ismail Sami Ikhtilaf Watkins. Ikhtilaf Watkins. Ismail Sami Ikhtilaf Watkins.
Ismari Sami Vasquez.
And defense, I believe I appointed the Office of the Public Defender yesterday to help him, was that a different individual?
It is Lafferty, Your Honor.
Okay.
I believe, he was recently seen, but he's being seen here today for the new law.
All right.
Violating the injunction, the domestic injunction.
All right, and sir, you are here on 2 counts. Count 1 is contempt of court for violation of an injunction of protection with regards to domestic violence. Count 2 is resisting officer or obstruction without violence. I'm appointing the Office of the Public Defender to represent you. Counsel, any comment in the case of Mr. Vasquez?
No, Your Honor, I just ask that you set a bond on the new cases. He does not appear to have any failures to appear, which is an indication he will show up to court. And I only see one conviction. I mean, his last conviction, excuse me, was in 2020. All of his convictions are nonviolent. That's it, DUI, actually. But no valid driver's
Please
license.
forgive me, I'm just trying to make sure I'm reading this paperwork right. The paperwork I have indicates that he has been arrested 4 times for battery, domestic violence.
Yes, Your Honor, however, no convictions.
Okay. And State, any comment?
He is entitled to bond on the new law, Your Honor. With regard to the out-on bond, it will be at your discretion as to do nothing, take no action, to revoke and hold him at no bond, or revoke and double the bond, Your Honor.
And sir, with regards to count 1 for violation of the injunction against protection for domestic violence, I'm setting bond at $5,000. You are to have no contact with the alleged victim, directly or indirectly. You are to maintain a separate residence. You are to consume or possess no alcohol or non-prescription drugs. You are to possess or control no weapons or firearms. any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. You are to maintain a distance of at least 500 feet from the alleged victim. That also includes 500 feet from their residence, vehicle, place of employment, place of worship, place of education, and any stores that you know that they go to. With regards to the bond on the prior battery DV cases, that would be cases 2022 MM 296. I'm going to revoke and set that at a no bond status.
Your Honor, just to clarify, the out on bond, is that 294 or 296?
296.
So what is the number for the new law?
Oh, hold on, no, you're right. It's 294, forgive me. You're right, it's 294 is the original.
I'm sorry, Your Honor, I missed on the resisting, what was the bond amount?
Thank you for, I'm not sure I addressed it. So on the
Okay.
resisting, it was set on the schedule at $500.
Thank you.
$5,000 de fianza y 500 del...
Would it be 5,000 for my bond and 500 for?
Yes, for the new law violations. However, on your out on bond, the court has revoked your out on bond and set you at no bond. You're gonna have to call the number I circled and speak with the attorney about trying to file a motion to see if they will reinstate your bond.
Ahorita por el momento no tengo fianza entonces.
So for the moment, I don't have any bond.
Not on the out on bond, no.
Y lo que me están poniendo aquí 5,000, ¿de qué es entonces?
So what are those $5,000 about?
Sir, if I may, forgive the interruption. We have a lot of people to go through today, and it appears that you have a lot of good questions for your attorney. Those questions would probably require a long session with your attorney. And so the attorney present here from the public defender's office is showing you a phone number that you can call, and you can ask all of those questions, okay?
Thank you, Your Honor.
All right, thank you, sir. Good morning. Please state your name, sir. Good morning. Your name, please?
White Corey.
And sir, you are here on a warrant arrest with regards to an underlying charge of burglary of a dwelling, occupied conveyance. The judge has set that at a no bond status. Do you understand what I have said?
Yes.
Now, did he have the PD appointed prior? Well, okay. We'll appoint you're right, it's a brand new. We'll appoint the Office of the Public Defender to represent you, sir. All right, thank you. Please state your name, sir.
Fernando where, sir?
And I'm so sorry, please repeat your name.
Fernando where, sir?
All right, thank you, sir. And sir, you are here on a warrant arrest with regards to two matters. Count one is tampering with a witness to hinder communication to a law enforcement officer. Count two is aggravated battery causing great bodily harm. The judge in that case has set these matters at a no bond status. I'm appointing the Office of the Public Defender to represent you. Do you understand what I have said, sir?
And Your Honor,
Yes, sir.
and Your Honor, he is entitled to a bond on both charges, so I'd ask that you set a bond on both charges.
And if you look at the warrant signed by the judge, it clearly indicates on the second page, defendant in jail, defendant is to be held, no bond, defendant poses danger to victim. IA judge not to set bond. Send to Division 16 for any pretrial release motions.
And I'm going to object, Your Honor. Per law, he is entitled to a bond. This is not a crime that is punishable by life in prison, which means he is entitled to a bond. If there is a fear for the victim's safety, the state has to file a pretrial detention motion in order to hold him at no bond. Because that has not been done, this is an issue we've already read before. They stated that if it's not a crime punishable by life in prison, he is entitled to a bond, and a bond must be set at IA's, Your Honor.
I'm going to defer to the judge that signed that warrant and ask you to set a hearing before that judge ASAP, and perhaps Madam Clerk can assist in contacting Division 16
Can't do that.
and having that judge. So one thing we can do then, and it might speed things up, is that I'm going to, because of the wording in that warrant, I'm going to refer initial appearance to the judge in Division 16. They put that language in there. It was quite clear. And so, who's Division 16?
And
Judge
will
Barber?
you give me a second?
And so,
I understand, Your Honor. I'm just for the record, I'm gonna object and ask that a bond be set, given that it's not a punishable by life in crime, punishable by life in prison, and a pretrial detention motion has not been set.
let me ask the state if they have any comment for the record.
Your Honor, I'm looking this case up, and I'm just looking at the clerk's notes. It does appear as though an amended information was previously filed, and there is a clerk note that says the arraignment and any defects was waived.
I mean,
They dropped it. It looks like you guys dropped it and picked it back up.
Right.
I'm so sorry.
you
Madam
might-
Clerk is indicating that someone called about this case in the morning. She's verifying.
Yes, they want this case to say no bond, because initially, if you look in Odyssey, there was a no cost estimate case, and it wasn't filed on it. So they issued the case with you. I was calling.
Okay. All right, and so I don't know if you heard what Madam Clerk said.
I heard what she said. I'm just arguing that
Okay,
it's an illegal detention of my client, given that a pretrial detention motion has not been filed, and this is not a crime punishable by life in prison, Your Honor.
All right, and State? I think you wanted to say something?
No, Your Honor, no.
All right, and so I will note all of the defense's objections. I think the fastest way to get this gentleman before the judge who issued this warrant and called again this morning to the clerk's office to make sure that it stated no bond status, I would ask, Madam Clerk, can you contact that division and see how soon we can get this gentleman before?
I would, Your Honor,
So let's do this, Madam
I'm
Clerk.
gonna have to.
I'm going to take a 5-minute break and let
Can we,
Madam Clerk
matter of fact,
take a
can we
phone
approach
call.
her? Can we approach, Your Honor? Just me and the state.
I don't know how to mute this, but it'll still record. I mean, it's. All right, going back on the record with the case of Mr. Ware. And at this point, it is unknown how soon we can get Mr. Ware before the judge in Division 16. The court acknowledges that the defense is making a very good point with regards to the setting of a bond at initial appearances. I was trying to get this matter referred to Division 16 for initial appearance in Division 16, but at this point, I don't know if we can do that. And of course, that would put Mr. Ware in a situation of being detained without being given a bond. And so at this point, I'm going to set bond and conditions of release. I believe the state has indicated that they have no objection. Is that correct?
That is correct, Your Honor.
And so at this point, I'm setting bond at $250,000 to have no contact with the victim.
Your Honor, there's two counts, so 250 on count one, and how much on count two?
Can I get that?
I think it's an aggravated battery, great bodily harm with a weapon, and tampering.
Thank you. Correct. Thank you. So, so count one, let me deal with it that way. Tampering with a witness to hinder communication, we'll set that at $2,500. Count two, aggravated battery by causing great bodily harm, we're setting that at $250,000 to have no contact whatsoever with the victim in the case, be that directly or indirectly. That means that you cannot talk to the person in person, you cannot text, email, or communicate with them by any other type of internet or social media platform. You cannot have another person try to communicate with them on your behalf. You cannot accept any communications from the alleged victim either. You are to consume or possess no alcohol or non-prescription drugs. You are to possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. I'm going to, let me see, require that you maintain a distance of at least 500 feet away from the victim at all times. That's 500 feet away from the person of the victim, their residence, their vehicle, their place of employ, their place of worship, their educational institution if they are studying, and any stores that you know that they frequent. Anything else, counsel?
No, Your Honor, thank you.
Anything else, state?
Nothing from the state.
All right, thank you.
I don't know, we gotta see when we can get you back in front of the judge.
I got one more question.
Oh, I don't know. I don't have any control over that.
Good morning.
Good morning.
Please state your name.
Kathy Mary Bass.
You are here on a violation of probation warrant with regards to an underlying charge of battery upon a person 65 years of age or older. The judge has set the bond on the warrant at $1,000. I'm appointing the Office of the Public Defender to represent you.
I'm sorry.
I'm appointing the Office of the Public Defender to represent you.
Okay.
Do you understand everything that was said?
I think $1,000, and I can't see that because I don't have my glasses. But how do I do that?
They'll tell you how.
Oh, here?
All right, thank you. Please approach and state your name.
Maria Warner.
I'm s-
Maria Warner.
Thank you. You are here on a violation of probation with regards to underlying charge of battery. I am appointing the Office of the Public Defender to represent you. Counsel, do you waive the reading of the affidavit of violation of probation?
Yes, Your Honor.
And I am going to inform you that the judge has set this at a no bond status. Thank you.
You were. I'm sorry. You were? Look at it. You absolutely were. This is gonna start which occurred after this. So you're gonna have to call the attorney.
We have the Creole interpreter, but after the next case, can we pull the Creole?
You gotta call the attorney because they're gonna keep going, but you were on probation.
Please state your name.
Timothy Walter Lafferty.
Thank you. Counsel?
Yes, Your Honor. Mr. Lafferty would like to accept the state's offer on the trespass after a warning in 2022 MM 4625AO and 2022 MM 4355AO of an adjudication of guilt, credit time served, and no return. While I finish the plea, can you look at the out on bond? I don't know what the address is for the no return.
Sure.
Thank you. And Mr. Lafferty would like to accept and enter a plea of no contest.
And state, is that the offer?
Yes, Your Honor.
All right, so I'm showing he's got, and this will be on both cases?
Yes.
So I'm showing he's got a case number 2022 MM 4355, and then the present matter is case number 2022 MM 4625. Is that correct?
Yes, Your Honor.
All right. And let the record reflect he has signed the plea form in open court.
Thanks, Your Honor.
You're welcome, sir. Let's finish with the plea. How many days time served does he have? Thank you. 3 days?
Oh, I was waiting for the.
On the new case or the out on bond, Your Honor?
Let's do both.
For the new case, it's 3 days, and I will have to look up for the next one.
You see it?
It is
8 days for the out on bond.
Thank you very much.
747
So he has a total of 11 days
Lancaster.
between the two.
Differently.
Right, 8 on one, 3 on the other, so total. All right. And, sir, did you review the plea form?
Yes, Your Honor.
Do you understand the rights that appear on the front of the plea form?
Yes, Your Honor.
Do you understand you are giving up those rights by entering a plea here today?
Yes, Your Honor.
Do you understand the maximum and minimum penalties for the charges that you are pleading here today on?
Yes.
Are you entering the pleas of your own free will?
Yes, Your Honor.
Are you under the influence of any alcohol, drugs, or medication that might affect your thinking here
No.
today? Do you suffer from any type of mental condition or disease that might affect your ability to think clearly?
No.
Do you understand that entering a plea of guilty or no contest to this charge can lead to deportation from the United States if you are not a legal citizen of the United States?
Yes, Your Honor.
Are you satisfied with the services of your attorney? With regards to the charge in case number 2022 MM 4355, trespass on property after warning, how do you plead?
No contest.
With regards to the charge in case number 2022 MM 4625, trespass on property after warning, how do you plead?
No contest.
I accept the pleas of no contest. I find you are alert and intelligent, understand the rights and the penalties associated with these charges. You are entering the pleas of your own free will, and there are sufficient facts to accept the pleas. At this point, I'm going to adjudicate you guilty on both charges. I'm going to give you credit for time served. On the prior charge, it's 8 days time served. On the new charge, it's 3 days time served. I'm going to require that you not return to the place where this incident took place for a period of 1 year, and that would be the Dunkin' Donuts at 6215 South Orange Avenue.
Yes, for
And then
1
the-
year. For 1 year.
And then the second location, Your Honor, is for the out on bond is 747 West Lancaster. Is it street?
I'm scared with this one. I live there. I live there.
So he's not to return to the Dunkin' Donuts, and what was the other place?
Yeah.
Mm-hmm. Is that a home?
No, it's a bugabilious.
Bugabilious? Yep, 747 West Lancaster.
I think it is street.
Okay.
747 is Maria's Restaurant. Got on board.
Yes, Your Honor. That's the
Share.
second. It's a restaurant, right?
Okay, thank you, sir, for the clarification. Sir, you have 30 days to appeal the decision of the court in writing. If you cannot afford an attorney for appellate purposes, one can be appointed for you if you qualify. Thank you, sir. Okay, on the one he was out on bond out was 8 days, and on the new one was 3 days. Please state your name, sir.
Hi, my name is Keith Rucco.
And, sir, you are represented by the Office of the Public Defender. I believe it was a possible plea, counsel?
Yes, sir. Is it okay if I state a comment, please?
Oh, wait for your attorney, okay?
All right. So are you? Your Honor,
Yes.
I tried to speak with the client. I advised him not to talk about the facts of the case. He still would like to speak with you about the case. And I asked if he wanted to accept the plea, and he states he just wants to talk to you.
It's up to you if you think at this point, counsel, it would be appropriate for him to address the court if you think that that is in your client's best interest.
I do not think it's in his best interest, Your Honor.
Sir, do you understand what your attorney is saying?
Yes.
And so if you say anything, it's going to be, there's always the possibility it can be used against you. It may affect how this goes forward. And so I would highly encourage you to follow your attorney's advice. And if your attorney's advice is not to address the court at this time, I would encourage you to highly consider that. At this point, sir, just to make you aware, you are here on a charge of trespass on property after warning. And I've reviewed the charging affidavit, find probable cause. The bond has been set at $500 on that case. Do you understand me so far?
Yes, sir, but I'm from out of county, so they're not gonna allow me to pay the $50. I'm from out of county, so they're not gonna allow me to pay the $50.
Got it. I understand what you're saying.
To get out.
Okay.
And another thing that's on the police report is that I did not.
Sir, and please forgive me. I don't mean to be rude, but everything you say is being recorded and can be used against you.
I would
okay?
like that.
And so if you believe that there is a defect in the arrest affidavit, that's probably something you want to discuss with your attorney.
I have already told her what I'm trying to state, and there's nothing that could be used against me for stating it.
All right. And so at this point, what I'm going to do, counsel, I'm not going to take a plea at this time. I understand that there may have been a plea offered, but I'm not going to take a plea at this time. But I understand his concern with regards to the bond amount. I'm going to, if the state has no objection, reduce the bond amount to $250 or mental health pretrial release, if he qualifies.
Thank you, Your Honor.
All right, sir?
Can I just say something, please?
No. And so just be in contact with the attorney, okay, sir?
Your Honor, the only thing I ask is that there be a no return.
All right, and then we're going to require that he not return to the place.
Greyhound Bus Station, 555 North John Young Parkway.
All right, thank you.
Mariana Nieves, rule on Elmer, refuse.
And I will waive the appearance, Your Honor.
All right, and for purposes of the record, I have appointed the Office of the Public Defender to represent Mr. Elmer O'Neill Nieves Grullón. And State, these were all set at no bond, attempted robbery with a weapon.
Yes, Your Honor. All of these are entitled to bond.
Right. And so with regards to count one, attempted robbery with a weapon, I'm setting bond at $2,500. With regards to
Yeah, he got issues.
count two, aggravated battery with a deadly weapon, domestic violence related, I'm setting bond at $10,000. To have no contact whatsoever, directly or indirectly, with the alleged victim in the case. To maintain a separate residence, not to consume or possess any alcohol or non-prescription drugs, not to possess or control any weapons or firearms. Any weapons or firearms within their control or possession are to be handed over immediately to law enforcement upon their release from custody. I'm going to allow him to return one time with the assistance of law enforcement to return to the residence to pick up personal possessions. I'm going to require he maintain a distance of at least 500 feet away from the alleged victim's person, their residence, their vehicle, their place of employ, their place of education, their place of worship, and any stores that he knows that the alleged victim frequents. With regards to count three, possession of fentanyl, I'm setting bond at $1,000. Count two, possession of cocaine, bond at $500. Count three, possession of drug paraphernalia, bond at $100. Right. Please state your name, sir.
Fernando P. Melli.
And sir, you are here with regards to 4 counts. Count 1, robbery by sudden snatching. Count 2, false imprisonment. Count 3, criminal mischief. Count 4, battery, domestic violence related. I have reviewed the charging affidavit and I find probable cause. I am appointing the Office of the Public Defender to represent you at this time. With regards to count 1, the robbery, bond is set at $150. With regards to count 2, false imprisonment, bond is set at $3,000. With regards to count 3, criminal mischief, bond is set at $100. With regards to count 4, battery, domestic violence related, bond is set at $5,000. To have no contact whatsoever with the victim in the case, directly or indirectly, that means that you cannot talk to the alleged victim in person, you cannot call them on the telephone, you cannot text them, you cannot email them, you cannot try to communicate with them by any way of internet or social media platform. You are not to have anyone else try to communicate with the alleged victim on your behalf. You are to maintain a separate residence from the victim. You are to, you can return one time with the assistance of law enforcement in order to retrieve personal possessions. You are to consume or possess no alcohol or non-prescription drugs. You are to possess or control no weapons or firearms. Now, State,
Yes, Your Honor.
there is an allegation of possession of an assault weapon in this case. And I don't believe that an order from me asking him to give any weapons to law enforcement immediately upon release would suffice under these circumstances. I am going to require law enforcement to go out and take possession of any weapons that he owns or controls.
They do that?
Because of Marcy's law, I'm not going to put an address on the record. And so therefore, I'm going to require law enforcement to look into this file, acquire the address, go to that premises, and take possession and control of any weapons or firearms that belong to this gentleman. Give him a receipt for it, and hold possession of those weapons until such time as a court orders that they be returned to him.
Do they do that?
I don't know. I honestly don't.
I've never seen them do that. I don't know if they can.
Well, I think under the circumstances, it's important that we eliminate the possibility of any weapons in this matter.
Your Honor, did you give him a one-time return with law enforcement?
Yes.
Maybe with the one-time return with law enforcement, when they're going at the same time, they can grab the weapons. Make that a part of the order that when law enforcement goes with him to get his belongings, they must pick up the weapons at the same time.
Well, that's a good idea, and I appreciate that, but he may not decide to exercise that option.
I was just trying to see, because I don't know if they'll go out, I don't know.
And I appreciate any comments and ideas, really, because I understand that it's not normally something that is requested or ordered by the court. I'm not requesting it, I'm ordering it.
My only comment, Your Honor, would be that he believes, or he being the father, believes that the defendant took the AR gun from under the bed and then left. So I don't think it would be at the residence anymore. I think the only way for it to be handed into law enforcement would be for the defendant to do so. Generally, what happens is the court will order that any weapons or firearms have to be turned into law enforcement within however many hours of their release. And then they explain, don't walk in with it, put it in the trunk of your car, let law enforcement know that you're coming.
My concern is that there is no, to my understanding, there is no enforcement mechanism for that. So I can order it, but if the individual decides not to do it, law enforcement is not triggered that there has been noncompliance, and therefore there's no way to enforce it because law enforcement has not been brought into the fold with regards to the order of the court. So what I am attempting to do is I am attempting to bring in law enforcement into the fold and require that they try to get possession of this weapon. And it may be that if it's not at the residence, perhaps the alleged victim may know where it is. Perhaps the defendant may share information with their attorney. I don't know. But under the circumstances, it's worth a try.
Okay.
Okay? And so, anything else for the record, State Defense?
Nope, Your Honor, so just to be clear, in the order, you're gonna state that law enforcement must go to the residence to pick up any weapons and firearms or?
Well, not just to the residents. We've been made aware that there is a weapon. And again, see, I don't know. As far as I know, the alleged victim may think it's an AR. It may be an airsoft gun. I don't know. But I'm requiring law enforcement to go out and figure this out. And if there's a weapon, even if it's not at the residence, if the weapon belongs to this gentleman, they need to find it and get control of it. I want it out of this scenario until further investigation and thought by the attorneys that are going to be involved in the case and by the judge involved in the case. Madam Clerk, be my guest at being as lengthy as possible in the paperwork with regards to what I'm requiring law enforcement to do. Yeah, I just don't want them to go to the residence. I want them to find this weapon. All right, thank you, counsel.
Whether you sign it or not.
Please state your name.
Justin Roman.
And, sir, you are here with regards to two charges. Count one is aggravated battery with a firearm, domestic violence related. Count two is aggravated assault with a firearm, domestic violence related. I've read the charging affidavit and I find probable cause. I'm appointing the Office of the Public Defender to represent you. I see that we have a person in the booth.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God? Can you speak into the microphone?
I do.
Thank you. Please state your name for the record.
Gary Tejada.
State, would you like to inquire?
Good morning. How do you know the defendant?
We have been in a committed relationship for about a year.
But please forgive me. We're having trouble hearing you. It might help because there's no one else in the booth. Is it okay if you pull down the mask? Would that, there's no one else around you. Oh, that's good.
We've been in a committed relationship for about a year.
Do you live together?
Yes, we do.
While this case is pending, would you like to continue living together?
Yes, I do not have any fear of him.
All right. Were drugs or alcohol involved in this incident?
Not that I have known of, no. We weren't, neither one of us.
Okay. And has something like this happened before?
No, I've never feared for my life. This is more of like something just out of the blue, nothing that I was formerly known of.
And please forgive me, I'm having trouble understanding what you're saying.
I'm sorry, I was saying that no, nothing ever like this ever occurred. I've never been afraid of him.
I have no further questions. Thank you.
Defense, any questions?
No questions, Your Honor.
All right. And so, with regards to count one, aggravated battery with firearm, domestic violence related, I'm setting bond at $5,000 to have no contact whatsoever with the alleged victim in this case. That means you cannot talk to her in person, you cannot telephone her, you cannot text or email, you cannot use any type of internet or social media platform to try to communicate with her. You cannot use another person to exchange messages between you and her. It also means that you cannot accept any communication from her. Do you understand that?
Yes, sir. I gotta pay $5,000 now.
That's the bond amount, okay? I'm going to require that you maintain a separate residence, that you...
I live with my mom in Kissimmee.
You live with your mom, okay, so...
Well, I'll go over there.
Maintaining a separate residence. I'm going to require that you maintain a distance of at least 500 feet away from the alleged victim. That means 500 feet away from her
Yes, sir.
person, from her residence, from her place of employment, her place of education, if she's attending school, her place of worship, any stores that you know that she frequents. I am also going to require that you possess or control no weapons or firearms. This is another case where there are allegations of a rifle and a handgun in the affidavit. I believe also there's an allegation of striking with a handgun. And so at this point, I'm going to require law enforcement to go out and take possession of any weapons that Mr. Roman owns or has control of, give a receipt for them, and hold on to them until such time as a court of proper jurisdiction orders their release. With regards to count 2, aggravated assault with a firearm, I'm setting bond at $2,500, the same conditions of release as I just stated on count 1. For purposes of the record, the defendant and the alleged victim do not live together, and so that means that law enforcement should look at the residence of the defendant for any weapons. Again, the defendant has the opportunity, if they wish, to communicate with their attorney and voluntarily hand these weapons in. And if that's done, then obviously law enforcement does not need to go out and look for them.
And Your Honor, I'm sorry, did you provide a one-time return with law enforcement?
I think they indicated they don't live together.
He lives there. He said he could live with his mother.
Oh, I'm so sorry. All right, and so I'm going to require that you maintain a separate residence from the alleged victim, and will allow you to return one time with law enforcement to recover personal possessions. Okay?
Okay, sir.
Anything else, counsel?
No, Your Honor, thank you.
All right, anything else, State?
No, Your Honor.
All right, thank you. Please state your name.
Jennifer Alexis.
And I'm sorry, I'm having trouble hearing you. Could you speak a little louder?
Jennifer Alexis.
Thank you. You are here on a charge of battery, domestic violence related. I have reviewed the charging affidavit and find probable cause. I'm appointing the Office of the Public Defender to represent you. I noticed that they had not had an opportunity to interview her. Do you know if there's any update as to whether or not she qualifies for a pretrial release?
She qualifies, Your Honor.
She qualifies, thank you. State, any position on this case?
No, Your Honor.
All right. Defense, any comment? I'm going to give an opportunity to Ms. Alexis to either post a cash bond of $1,500. Oh, I'm so sorry.
I was gonna
Thank
leave.
you for letting me know.
Raise your right hand, please. Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
Please state your name for the record.
Cedric Michael Jane Bart.
Good morning. State, do you wish to inquire?
Yes, Your Honor. Good morning, sir. How do you know the defendant?
This is my wife.
I need you to speak just a little bit closer to the microphone.
This is my wife, the mother of my child.
Do you live together?
Yes, ma'am.
While this case is pending, would you like to continue living together?
If she want to, but I don't want personal charges.
Okay.
Don't want
Has
to
something like this happened before?
No, ma'am.
Were drugs or alcohol involved in this incident?
No, ma'am.
And one more thing, I'm sorry, you said mother of your child or children?
Mother of my child. One of my child.
Was your child present during this incident?
Not really.
What does that mean, not really?
She was not around that time.
Okay.
Yes, ma'am.
I have no further questions, Your Honor.
Defense, any questions?
No, Your Honor.
All right.
And as to bond, she would prefer a monetary bond, Your Honor.
Okay, and so I'm going to set bond at $1,500. You are to have no, I'm so sorry, he's signaling.
Excuse me. What you talking about the bond?
Okay, so just to explain to you, sir, that qualifies for pretrial release, but it's, I've given an option. She can either do pretrial release where she doesn't have to post a bond, or she can post a bond of $1,500. She can do that as a cash, full $1,500, or she can use the assistance of a bonding agent and pay 10% of that. Under these circumstances, I give an option because pretrial release may mean some type of supervision, whereas a cash bond, there is less supervision. The bonding agent is more concerned with making sure that they appear in court.
I'm gonna pay the bond. I will pay for the bond.
Okay, okay. And so I just wanted to clarify that
I will pay
question
for the
for
bond.
you, okay? And so, based upon the history and the comments by the alleged victim, I'm going to require no hostile contact between you and the alleged victim in the case. That means that if there is any type of alleged hostile contact and the police are called, it's going to be a much worse situation for you. Do you understand what I've said? I'm also going to require that you possess or consume no alcohol or non-prescription drugs, that you possess or control no weapons or firearms. Any weapons within your control or possession are to be handed over immediately to law enforcement upon your release from custody. Okay?
I don't have either. Okay.
All right, thank you. And counsel, anything else?
Hey,
Your Honor?
Yes, State?
There's an indication that DCF will be contacted. So if you could just make one other condition that she comply with any DCF plan that may be put in place?
Defense?
huh?
No objection.
All right, and so I will require, Ms. Alexis, that you comply with any plan that is put in place by the Department of Children and Family. All right, thank you.
Hey.
Please state your name.
Taylor Frazier.
All right. And you are here on a charge of battery, dating violence related. I've reviewed the charging affidavit and find probable cause. I'm appointing the Office of the Public Defender to represent you at this time. I do see there's a gentleman in the booth. If you would please swear him in.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, to help you God?
I do.
Please state your name for the record.
Cameron Holochek.
And State, do you wish to inquire?
Yes, Your Honor. Good morning, sir. How do you know the defendant?
It's my girlfriend.
Do you live together?
No.
While this case is pending, would you like to have contact with her?
Yes.
Has something like this happened before?
No.
Are you afraid of her?
No.
Were drugs or alcohol involved in this incident?
No.
I have no further questions, Your Honor.
Defense, do you wish to inquire?
No question. And Your Honor, she does qualify for pretrial release. Given she has no history, we would ask for pretrial release in this case.
I don't, the paperwork indicates that she qualified for pretrial release? I'm so sorry, I didn't hear.
Qualifies.
Oh, thank you. State, any position?
No objection, Your Honor.
Referring to the gentleman in the booth, you say that you all don't live together?
No.
And how long have you known each other?
2 years.
Based upon my questions, State, do you have any questions?
No, Your Honor.
Defense, do you have any questions?
No, Your Honor. Given his testimony, I would just ask for a no hostile contact order, given she has no domestic violence history, Your Honor.
All right, I'm going to agree to pretrial release. I'm going to agree to no hostile contact between you and the alleged victim. That means that if there is hostile contact and someone calls law enforcement, the situation is going to be much worse for you. All right? I'm going to require that you possess or consume no alcohol or non-prescription drugs, that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release. Anything else, State?
Nothing from the State.
Anything else, Defense?
Nothing from defense, Your Honor.
All right, thank you.
Harris Darius, behavior, Your Honor.
Okay, addressing the case of Darius Harris, I'm appointing the Office of the Public Defender to represent him.
I will waive the appearance, Your Honor.
And I am setting on count one, it's a two-count arrest affidavit. Count one, battery, domestic violence related. Count two, resisting officer without violence. On count one, by the way, I found probable cause. Count one, I'm setting bond at $2,500 to have no contact directly or indirectly with the victim in the case, to maintain a separate residence from the victim, can return one time with the assistance of law enforcement to retrieve personal belongings, to possess or consume no alcohol or non-prescription drugs, to possess or control no weapons or firearms. Any weapons or firearms within the control or possession of the defendant must be handed over to law enforcement immediately upon his release from custody. With regards to count two, resisting officer without, I'm setting bond at $100. Anything else, State Defense?
Nothing from the State.
Nothing from defense.
Thank you. Please state your name, sir.
Apache Hunt, sir.
Sir, you are here on two matters. Count one is battery, domestic violence related. Count two is petty theft. I've reviewed the charging affidavit. I'm sorry, this was via an arrest warrant. Yeah, that's an arrest warrant. I'm going to set the following terms of bond and release. Count one, battery, domestic violence related. I'm going to set bond at $2,500. You're to have no contact whatsoever with the victim in the case. That's directly or indirectly.
Yes, sir.
That means that you cannot talk to the person in person. You cannot telephone them, email them, text them, communicate by any type of internet or social media platform. You cannot have a third person try to communicate on your behalf either. And that also means that you cannot accept any communication from them. You are to consume or possess no alcohol or non-prescription drugs. You are to possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. You must maintain a distance of at least 500 feet away from the alleged victim at all times. That means the person, their residence, their vehicle, their place of employ, their place of worship, their place of education, and any stores that you know that they frequent. I believe I indicated maintain a separate residence. You may return one time with the assistance of law enforcement to retrieve personal belongings. With regards to count two, petty theft, I'm setting bond at $500. Anything else, State Defense?
Nothing from the State.
Nothing from defense, Your Honor.
All right, thank you. please state your name.
Nanhun, my honor. My name is Nanhun.
All right, thank you. And sir, you are here on a matter of battery, domestic violence related. I've reviewed the charging affidavit and I find probable cause. I'm appointing the Office of the Public Defender to represent you at this time. I'm going to set bond at oh, I'm so sorry. Thank you for letting me know. We have a person in the booth. Good morning.
Good morning, Your Honor.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
I do.
Please state your name for the record.
Gwen Lee Pham.
All right. And State, do you wish to inquire?
Thank you, Your Honor. Good morning, ma'am. How do you know the defendant?
We have a relationship, and I have 2 little boys with him.
Do you live together?
Yes, ma'am.
While this case is pending, would you like to continue living with him?
No, ma'am.
Okay. Has something like this happened before?
Throughout our relationship.
Are you afraid of him?
When he have alcohol in him, yes, I'm afraid of him. He too totally different person when he drink and not drinking. So
Were drugs or alcohol involved in this incident?
always alcohol involved.
Thank you. I have no further questions.
And I'm so sorry, I didn't hear that answer to the last question with regards where alcohol or drugs.
Always involved in a fight.
Okay, thank you. Any questions, defense?
No questions, Your Honor.
All right. Anything further from the state? Ma'am, did you want to let us know anything else?
I want to get injunction against him, please.
All right.
Yes, because otherwise he will come around a lot.
Okay. And so I'm going to inform you that we're dealing with the criminal case at this time. An injunction is a proceeding you can do today. It's a different proceeding, all right? Can she go to the clerk's office downstairs and inquire about an injunction? She would have to go to the downtown clerk's office? Now, would they be able to help her with that, or would she need to go to a shelter or something like that to have her help with the paperwork?
I know usually they do. I'm not sure the other process.
Do we know if the victim advocate is around here?
Usually I would see her downstairs, Your Honor. I did not see her this morning. She may still be downstairs, but I didn't see her when I went downstairs.
All right, Madam Clerk is indicating to me that either a victim advocate may be able to help you, apparently may not be here today. If they are, would they be around the first floor?
Yes, Your
It
Honor.
would be around the first, so she can inquire downstairs on the first floor if there is a victim advocate.
Yes, Your Honor.
And if so, you can ask the victim advocate for assistance with regards to a restraining order. Madam Clerk is indicating that if there is no victim advocate in the building, that you can go to the downtown courthouse. You know where the downtown courthouse is?
Yes, Your Honor.
All right, and that you can inquire with the clerk's office there about an injunction. But please understand that it's a separate proceeding, and you have the ability to go now and try to get that in place if you wish.
Yes, Your Honor.
Okay, but I am going to put certain conditions as well on this case, but it's not going to be the same as an injunction against domestic violence. So I just want to make sure that you understand that that is an important process that you can follow. And you can do that immediately as soon as you leave from here.
Yes, Your
Do you
Honor.
have any questions about anything I've said?
No, Your Honor.
Okay. And so at this time, I am going to set bond at $10,000. You are to have no contact whatsoever, directly or indirectly, with the alleged victim in this case. That means that you cannot talk to her in person, you cannot telephone her, you cannot text her, and you cannot use any type of internet communication or social media platform to communicate with her. You must, and you cannot use another person to send messages to her. Do you understand what I've said? You cannot, you must maintain a separate residence, so you cannot return to your residence with her. You can return one time with the assistance of law enforcement. So that means that you must communicate with law enforcement and arrange for them to go with you to the residence in order to pick up personal belongings. I'm going to require that you consume or possess no alcohol or non-prescription drugs. I'm going to require that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. I'm going to require that you keep a distance of at least 500 feet away from her. And that means 500 feet away from her person, from the residence, from her vehicle, from her place of employ, from her place of worship, from her place of education if she is attending a school, and from any stores that you know that she frequents. Is there any place else you would like him not to go to?
No, Your Honor.
All right. And I think I've addressed all, oh, yes, been made aware that he is out on a DUI, and it was a PTD pending. I am going to revoke the PTD and set this at a no bond status. Thank you, sir.
I believe he has a private attorney, Your Honor, on the out on bond. So I just ask that you appoint us only to the battery.
On the DUI?
Yeah, he has a private, I believe, Your Honor.
And that's surely, so if that attorney has filed a notice of appearance, that'll take, then that's who will be representing him on the DUI. The public defender's office will be only on the battery.
Thank you.
All right. Please state your name.
Willie McCarthy.
Please bear with me a second. Thank you so much. Mr. McCarthy, you are here on a matter of battery, domestic violence related. I reviewed the charging affidavit, and I find probable cause. I am appointing the Office of the Public Defender to represent you. I'm setting bond in this case at $2,500. You are to have no contact whatsoever with the alleged victim in the case. You must maintain a separate residence from the victim in the case. You are to, when I say no contact with the victim in the case, that means that you cannot talk to them in person, you cannot telephone them, email them, text them, use any type of internet or social media platform to communicate with them, and you cannot accept any communications from them. You, as I said, must maintain a separate residence, although there is an allegation that he does not live there.
Yeah, he doesn't.
But just in case, I'm going to require that you not live at that address with the alleged victim, that you consume or possess no alcohol or non-prescription drugs, that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. And you are to maintain a distance of at least 500 feet away from the alleged victim. That means their person, their residence, their vehicle, their place of employ, their place of worship, their place of education, and any store that you know that they frequent. All right, sir? Do you understand everything I've said? All right, thank you. Counsel, anything else?
No, Your Honor.
All right, state, anything else?
Nothing, Your Honor.
All right, thank you. Good morning. Please state your name.
Ebony McFarley.
You are here on a charge of battery, domestic violence related. I have reviewed the charging affidavit and I find probable cause. I'm appointing the office of the public defender to represent you at this time. I'm setting bond. Please bear with me a second.
Okay.
She doesn't qualify for PT, correct?
He does not, Your Honor.
I'm sorry?
He does not.
She does not. Okay, thank you. Setting bond at $1,500. You are to have no contact whatsoever with the victim in the case. That is directly or indirectly. That means that you cannot talk to them in person. You cannot call them, text them, email them, use the internet or any type of social media platform to communicate with them. And also means that you cannot use a third person to relay messages, and you cannot accept any communication from them. You must, there's an indication that they don't live in the same residence, but I'm still going to require that you maintain a separate residence, that you consume or possess no alcohol or non-prescription drugs, that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. You must maintain a distance of at least 500 feet away from the alleged victim, 500 feet away from the person, from their residence, their vehicle, their place of employ, their place of worship, their place of education, and any store that you know they frequent. Anything else, state defense?
Nothing from the state.
Nothing from defense.
All right, thank you, ma'am. 1,500. Please state your name, sir.
Pierre Postel.
Sir, you are here on a charge of battery, domestic violence related. I have reviewed the charging affidavit, and I find probable cause. I'm appointing the office of the public defender to represent you. I'm setting bond at $2,500. You're to have no contact whatsoever with the alleged victim in the case. That means that you cannot talk to them in person. You cannot call them on the telephone. You cannot text them, email them, try to communicate by any type of internet or social media platform. And you cannot have anyone else try to convey communication on your behalf. You must maintain a separate residence from the victim in the case. You are allowed to return one time with the assistance of law enforcement to retrieve personal belongings. You are to consume or possess no alcohol or non-prescription drugs. You are to possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. That already does 500 feet?
No, not yet.
You must maintain a distance of at least 500 feet away from the alleged victim. That means 500 feet away from herself, from her residence, her vehicle, her place of employ, her place of worship, her place of education, and any store that you know she frequents. Anything else, state defense?
Nothing from the state.
Nothing from defense, Your Honor.
Thank you. Thank you, sir. Correct, no contact. Please state your name.
Ashley Quiles.
And you are here on a charge of battery, domestic violence related. I have reviewed the charging affidavit and I find probable cause. I'm appointing the office of the public defender to represent you at this time. I'm setting bond at, she doesn't qualify for PTR, correct?
No, Your Honor, she didn't.
All right, thank you. I'm setting bond at $1,500. You are to have no contact whatsoever with the alleged victim in the case. That means directly or indirectly. That means you cannot talk to the alleged victim in person. You cannot telephone them. You cannot try to contact them by text, email, any type of internet access, or any type of social media platform, and you cannot have another person try to communicate on your behalf. You must maintain a separate residence from the alleged victim. You can go one time, you can return one time with the assistance of law enforcement to retrieve personal belongings. I'm going to require that you consume or possess no alcohol or non-prescription drugs, and that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. I'm going to require that you maintain a distance of at least 500 feet away from the alleged victim at all times. That means 500 feet away from the victim, from their residence, their vehicle, their place of employ, their place of worship, their place of education, and any store that you know they frequent. Anything else? State defense?
Nothing from the state.
Nothing from defense.
All right, thank you.
That's my house.
Bear with me a moment, please. Please state your name.
Charlie Luis Saldana Hernandez.
Sir, you're here on a charge of battery, domestic violence related. I have reviewed the charging affidavit and I find probable cause. I'm appointing the Office of the Public Defender to represent you. Please bear with me a second.
Yes, sir.
Your Honor, in this particular case, I would ask, as far as his out on bond is concerned, I would ask, as opposed to holding him at no bond, you consider revoking and doubling. If you read the facts of this case, it appeared the alleged victim was trying to break his computer and he was trying to stop it from occurring. The facts aren't egregious. The out on bond offense is not a violent offense. So I just ask that you consider revoking and doubling as opposed to holding him at no bond, given these particular facts and the fact that he has no domestic violence history.
Let me deal with the with the charge that brings him here today, then we'll talk about the second one, because I did have a question about that matter he was out on. But with regards to this particular case, and he does not qualify for pretrial release, correct?
No, yeah, he doesn't.
I'm going to set bond on this case at $1,500. I'm going to require that you have no contact with the victim in the case. That means directly or indirectly. You cannot communicate, you cannot talk to them in person, you cannot call them, text them, email them, try to communicate via any internet access or any social media platform, and you cannot have another person try to convey a message on your behalf. That also means that you cannot accept any communication from the alleged victim at all. You must maintain a separate residence. You are allowed to return one time with the assistance of law enforcement in order to retrieve personal belongings. You are to possess or consume no alcohol or non-prescription drugs. You are to possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. You must maintain a distance of at least 500 feet away from the alleged victim in the case. That means 500 feet away from the person, from their residence, their vehicle, their place of employ, their place of worship, their place of education, and any store you know they frequent. Now, with regards to this part, is there any comment from the state or the defense?
As to the new law, Your Honor?
No. Yes, that's the new law.
No questions, Your Honor.
All right. Now, with regards to the matter that had him out on PTD, I was trying to understand what this case was and could not access it on my system. But I have it as an offense against computer users. Can someone educate me as to what the case that he was out on PTD was?
Let's see.
Your Honor, may we approach?
Do you wish to go off record?
No, I just don't wish to say this in open court.
Well, there's no way to, my understanding, there's no way to mute this up here, is that correct? You can mute it? Please approach. In case number 2021 CF 9808, does the state have a position with regards to his PTD status on that case?
Your Honor, I generally ask the court to take no action and allow the state to review the information and then make a decision based on their review.
And defense, any comment?
No objection, Your Honor.
All right, and so I am going to therefore take no action on the matter with regards to his PTD in case 2021 CF 9808.
What was that?
Anything else, state defense?
Nothing from the state, 1500.
All right, thank you, sir.
Here you go.
Please state your name.
Stetson Senator.
You're okay. Brenda, you're okay.
And sir, you are here on a matter of battery, domestic violence related. I have reviewed the charging affidavit, and I find probable cause. I am appointing the Office of the Public Defender to represent you. I'm setting bond in this case at $10,000. You are to have no contact whatsoever, directly or indirectly, with the alleged victim in this case. That means that you cannot talk to them in person, you cannot call them, you cannot email them, text them, any type of communication via any type of internet platform or social media platform, and you cannot have another person try to communicate with them on your behalf. You are to maintain a separate residence from the alleged victim in this case. You may return one time with the assistance of law enforcement to retrieve personal possessions. You are to consume or possess no alcohol or non-prescription drugs. You are to possess or control any weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. You must maintain a distance of at least 500 feet away from the alleged victim in this case. That also includes 500 feet away from their residence, their vehicle, their place of employ, their place of education, their place of worship, and any store that you know that they frequent. Anything else, State Defense?
Nothing from the state.
Nothing from defense, Your Honor.
Thank you, sir.
And Lee, behavior, Your Honor.
Okay. With regards to Span Lee, I am appointing the Office of the Public Defender to represent him.
I will waive the appearance, Your Honor.
And this is with regards to a matter of battery, domestic violence related. I have reviewed the charging affidavit, and I find probable cause. I'm setting bond in this case at $7,500 to have no contact with the victim in the case, directly or indirectly, to consume or possess no alcohol or non-prescription drugs, to control or possess no weapons or firearms. Any weapons or firearms within their control or possession are to be handed over immediately to law enforcement upon their release from custody. They must maintain a separate residence, can return one time with law enforcement to retrieve personal belongings, to maintain a distance of at least 500 feet away from the alleged victim, from their residence, their place of employ, their vehicle, their place of worship, their place of education, and any store. No, the defendant knows the alleged victim frequents. Anything else, State Defense?
Nothing from state.
Nothing from defense, Your Honor.
Thank you. Please state your name.
Elijah Tillman.
Tillman?
Yes, sir.
All right, and sir, you're here with regards to a charge of battery, domestic violence related. I have reviewed the charging affidavit and I find probable cause. I'm appointing the Office of the Public Defender to represent you. I am setting bond in this case at $7,500. You are to have no contact whatsoever with the victim in the case. That means that you cannot talk to them in person, you cannot telephone them, you cannot text them, email them, try to any type of communication through the internet or through any type of social media platform, and you cannot have another person communicate with the alleged victim on your behalf.
Yes, sir.
That also means that you cannot accept any communication from the victim as well. I'm going to require that you maintain a separate residence from the victim. You may return one time with law enforcement in order to retrieve personal belongings. I'm going to require that you consume or possess no alcohol or non-prescription drugs. I'm going to require you control or possess no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement
No, sir.
upon your release from custody. I'm going to require that you maintain a distance of at least 500 feet away from the victim at all times. That's 500 feet away from the individual, from their residence, their vehicle, their place of employ, their place of worship, their educational institution, and any store that you know that they frequent. There is an indication here that you are out on bond on another charge of battery, domestic violence related. I am revoking that bond and setting that at a no bond status. Anything else, State Defense?
Nothing from the state.
Nothing from defense, Your Honor.
Thank you.
So I have a bond for this one?
You have a bond of $5,000 on this one, but the bond that you were out on for the other allegation of domestic violence, I've revoked that and set that at a no bond status. When you communicate with the attorney, they'll let you know what'll happen next with that. All right. All right.
Okay.
If you have questions, I just want to let you know everything you say is being recorded can be used against you. If it's a question that your attorney can answer, I prefer that you talk to them.
Attorney, how would I get a hold of them? But I do have a bond for this case.
All right, thank you, sir.
No, hey, Michael Anthony, that released to Brevard County.
I'm so sorry, what happened with Mr. Hay?
Hayes got TOT to Brevard County.
So he already was transported to
Got
Brevard?
released to another county.
He got released already to another county. All right, thank you. Please state your name.
Philip Jagers.
And sir, you are here with regards to an out-of-county warrant from Osceola County regarding a charge of grand theft. bond on that has been set at $2,500. Do you understand what I've said? All right, thank you, sir. Okay, Marisol Rodriguez bonded. Johnny Santiago is medical? All right, let me just put this on the record. He's here. I know I can't appoint the public defender at this time because he's out of county.
You can temporarily appoint, Your Honor.
We will temporarily appoint the office of the public defender. He's
And
here on out-of-county warrant from Lake County. The judge has set those matters at no bond status.
Thank you, Your Honor.
Please state your name, sir.
I'm sorry, Your Honor, and for the previous case, defense will waive the appearance.
All right, thank you. I'm sorry, sir, please state your name. All right, you are here on a violation of probation warrant with regards to an underlying charge of delivery of a controlled substance. The judge has set this at a no bond status. I'm appointing the office of the public defender to represent you. You understand what I have said?
Yes.
All right, thank you. Please state your name.
Andrew Ford.
And sir, you are here on a warrant with regards to a violation of probation, and the judge has set that at a no bond status. I'm appointing the office of the public defender to represent you. You understand everything I've said?
Say what? I'm here for
Do
what?
you understand what I said?
You said I'm here for what?
Violation of probation
Oh, okay, okay.
in bear with me a second here. It appears to be a violation of probation with regards to an underlying charge of shooting at, within, or into a building. All right, sir, and the judge has set that at no bond status. Thank you. Please state your name.
Suelene Guerrero Rivera.
You're here on a violation of probation warrant with regards to an underlying charge of petty theft. The judge has set this at a no bond status. I'm appointing the office of the public defender to represent you. Thank you.
Good morning, sir.
Good morning. Please state your name.
Shamar Henry.
And sir, you are here on a violation of probation matter. Bear with me a moment, please. underlying matter was an aggravated assault with a deadly weapon and battery. And the judge has set the violation of probation in a no bond status. I'm appointing the Office of the Public Defender to represent you.
That's your original offense, you were put on probation? That's what he's saying.
All right, thank you, sir. Jeremy Lutz is a violation of probation.
I will waive the appearance, Your Honor.
Okay, and he's here on two matters. With regards to the violation of probation, I'm appointing the Office of the Public Defender to represent him. And on the violation of probation, that is set at a no bond status. I also have an affidavit with regards to possession of methamphetamine, and I've reviewed that charging affidavit, find probable cause. Bond on that matter has been set at $1,000. He has three cases? Let me see. Got one, two. He's got another violation of probation. There it is. He's got a third matter, which is a violation of probation in case number 2021 CF 2751. And the judge has set that at a no bond status as well. Anything else from the state defense?
Nothing from the state.
Nothing from defense, Your Honor.
Thank you. Please state your name.
Javon Spencer.
You're here on a violation of probation warrant with regards to an underlying charge of dealing in stolen property. The judge has set this at a no bond status. I'm appointing the Office of the Public Defender to represent you. Thank you.
Would I be allowed to ask you a question?
If you would run it through the attorney first.
So like you can't see that? He's not here.
I don't know why he's not here. You have to speak to him, but if it's a violation of probation. Your Honor, I'd ask that you not appoint us. What's the name of the attorney? He hired Roger Wheaton.
All right, and so at this point then, we will not require the Office of the Public Defender to represent them, as there has been a statement by the defendant that he has hired Attorney Whedon. All right,
Yes.
thank you.
Thank you.
Please state your name.
Jose Armando Vela.
You are here on a violation of probation with regards to an underlying charge of simple battery. The judge has set that at a no bond status. I'm appointing the Office of the Public Defender to represent you.
Yes, the only VOP that I know of is one that I had for burglary, but I've been recently incarcerated in another state, 7 months, so I don't know what this battery comes from. Or...
And so that's a question you can ask the public defender that is representing you, okay?
Also has another case, Your Honor.
Yeah, it's a...
Let's see. Violation.
Your Honor, he has a second VOP.
I see. It would be, is it Jose Armando Vela?
From
Yes, Your Honor.
All right, thank you.
April 2nd.
And so with regards to the second matter, it's two, I've got it as two violations of probation. One with regards to a charge of burglary of a structure or conveyance and petty theft, third degree. In that case, the judge has set the violations at no bond status as well.
You're on probation for battery. You violated that probation. For failing to report to the probation officer. They have a list of stuff. It's the same thing for all the other offenses. Change in residence, so you're gonna have to wait, speak to the attorney, see if they can file a motion to get you a bond, your bond reinstated.
Get out from probation. What's this for the,
That's not 6126. That's not what they're saying. I'm telling you, I'm looking at it right now. You're gonna have to speak to the attorney because that's not what they're saying. You're on probation for that since April. Burglary, simple battery. Yeah, you violated, so
Your Honor, did you want to do the 33-day motions now, or did you want to do them beginning of second session?
We'll do a little time management once council finishes with her client.
I'm telling you, I'm looking at it. You have a violation of probation on a battery. I know what you're saying. I'm telling you, it's right here. I'm looking at it. And you're telling me they did it. This, two simple battery, sentence date, 2 years. Violation, failing to make truthful. This is what he said. No, I'm just in November of last year. They did a violation of probation. So you're gonna have to speak to the attorney. He can't change it.
We're missing someone? You want to hold on to that? Thank you. All right, and so,
You can do them. I'm ready.
defense, any questions with regards to the last gentleman?
No, we're
All
okay,
right,
thank you.
Thank you. And so at this point, I believe we're done with the first session.
We
can go off record momentarily then.
have the 33-day motions.
Well, do you want to do that now, or do you want to do it when we
You
come
wanna do
back?
second?
I don't care.
But it's up to the state.
It appears like we got a lot.
Yes, Your Honor.
So I look at you, and when do you want to address them? Do you want to do it now or later?
I don't mind. Your Honor, I heard that it was a rocket docket, but I would actually ask if we could return at 1. I apologize, I'm tired. Sorry.
Will you be here the rest of the week?
I will be here Thursday and Friday, Your Honor, yes.
And so I would definitely consider breaking the days that you are here.
Thank you.
And so it also, well, this is time management. We don't need to be projecting this. But let's go off